Another case we had. I thought, you know which case, Attorney Perkins, APA Parish is handling your case. She should be here in a moment.
Okay. Hey.
Attorney DiMaggio,
Yes, Your Honor.
you need to speak to your client, Mr. Gary.
No, we've already spoken.
Okay. This is case 2356766, the people of the state of Michigan versus Aaron Keith Gary. Mr. Gary is charged with count 1 and only count 1 of weapons carrying concealed except for a probable cause conference today. Appearances.
Good morning, Your Honor. This is Dan Buchanan on behalf of the people, P number 86690.
Good morning, Judge Andrew DiMaggio, P 45619, on behalf of Aaron Gary, who should be present on Zoom.
Mr. Gary, unmute your device and state your name, please.
I'm Aaron Gary.
Attorney DiMaggio, do you have discovery?
Yes, I'm pretty sure. Yeah, I've looked at it, so I do have it.
Okay. Are you looking to set an exam date?
Yes, Judge.
Okay. You have July 20th available at 9:30.
Yes, that's a good date.
Okay, July 20th at 9:30. Mr. Gary, can you hear me?
Yes.
Your exam has been set for in-person at 36th District Court for July 20th at 9:30 a.m. Understood?
I won't be in town on that day.
Attorney DiMaggio, can you speak to your client, please?
Yes, Judge. Is that the only date that you have, the 20th? There's nothing after that?
There are dates after that. My question to you, Mr. Gary, where are you going?
I got my god sister is getting married. I'm at her
I can't
wedding.
hear you.
My god sister is getting married. I'm at her wedding,
When you coming back?
the 23rd.
24th, 9 o'clock?
Just check. Let me just check, Judge. That's a good date. That time too. 9:30. Is it 9 o'clock?
Actually, let's do 9:30. That's better.
All right. Sounds good, Judge. Thanks for being accommodating.
Of course. 24th at 9:30 in person. You understand that, Mr. Gary?
Yes, I do. Thank you.
All right. Y'all both have a good day.
You too. You and your staff. Thank you.
Thank you. Attorney Rosenberg. Is this gonna be a whole?
Yes.
Okay. We have a couple more things, and then we'll get started. Can you put this in Robertson file that Charlotte? Rich just, the one you just heard. So I gotta refer to next time. This is to, nothing sent back to us office, Judge? Okay, we do it next week. Did you receive this marriage?
Good morning, Your Honor.
Good morning. For recent town rule, did you ever receive a request for adjournment from Attorney Cripps?
I did not. Did he say how far out, Your Honor?
The 28th is his request.
Pardon me?
He requested 28th. I think it was sent to Mr. Kirker only.
Oh, okay.
No, it was sent to Kirker and Miss Parrish. It was sent Friday.
Oh, was it?
Yeah.
Oh, well, we were here in court, Your Honor. I probably overlooked it.
We're here to report.
That's, I don't have any objections. If he gave a good reason, Your Honor, I'll leave it up to you.
Okay. It says he'll be out of town. You have an issue with 28th, do you want to speak to?
I don't believe so. I think it's fine, Your Honor.
Okay.
I will, if there is an issue when the witnesses come, I will I will ask, I'll let you know, thank you. The process is.
Okay, so council will be adjourned to the 28th of July. 9 o'clock. Thank you.
That's on today at 10. Okay.
Alright. So I emailed Oldtree back and told him to move it. He didn't respond. So Barbara was the reason why I had to, she had to respond.
Okay.
But it's gonna be an adjournment because. You're in question. It will be adjourned, but I have to address it. When they get here. Okay. And Mr. Brooks, Carriage, and Kurt. Oh. Okay, let's handle Ewing and then we'll be starting with, Wilburn.
Madam Mayor, I'm just indicating that, this has for you, again.
Yeah.
Okay.
Oh, you know what, let me handle Mr. LaPenta, we have a tether violation.
Okay.
Yes, sir.
Give me one moment, Mr. LaPenta, I have to read the report here.
Yes, Phil is here. Can you hear me?
Yes, give me a moment, I'm reading your report.
Oh, okay, sir. Ma'am, I'm sorry. Can't see very well.
I'm gonna read it first. Okay, we're gonna turn. Okay. I'm just going to, so you may have to put my question. So she can have it. Okay, who's gonna have to tell the violation? Here's the answer report. Give you a moment to look over it.
Thank you, Your Honor.
And then you can also let me know what you think we need to hire a counsel or just address it. Okay.
Yeah.
Do it to the council appointed. If not, he can't say anything. And then I'll just.
I always err at the side of caution, I would say, probably.
All right, Mr. LaPenta, I'm going to, get you an attorney. Give me a moment. We have to call over the third circuit to appoint someone to you. They'll log on and you can speak in private with the attorney, then we'll go on the record, okay?
You said I can't understand.
Okay, so I'm going to have the clerk appoint you counsel, an attorney, to handle your tether violation. So
So,
it should take about 15 minutes to get the attorney present. He or she will be on Zoom, and then I'll put you onto a private breakout room so you can discuss the tether violation hearing. So just be patient and hold on. We're gonna get an attorney and I'll put you in the room so you can talk in private and then we'll go on the record, okay?
well, I really think you say sit here, okay. Good. I put myself back on mute, ma'am.
Oh, I guess you did. What did you say, Mr. Lopez? I didn't hear you.
Should I put myself on mute until that time?
You're fine as long as you're not talking.
Oh, okay then.
Okay, Ms. Parrish, right, are you doing? No, ready is the first one. Let's do this. We'll just keep popping up on here. Attorney Woodside, good morning.
Good morning, Judge. I have located Mr. Powell, who you KPS on Friday. Mr. Powell is in Central Michigan Correctional Facility.
Okay.
So-
I'll lift the warrant and we have to still set a time for an arraignment because it was entered in the system for Friday.
Okay.
We can do arraignment and the PCC on the same day if you want in this courtroom.
Okay. So you just,
Which facility is he in?
Central Michigan Correctional. That's in St. Louis, Michigan, 320 Hubbard, South St. Louis, Michigan, 48880. Do you want the phone number? Should I give it to Madam Clerk?
What is his name first? She's gonna write down the actual file.
His name is James Powell.
How? Okay, all right, and what's the number?
The phone number is 989-681-6668. Do you want his inmate number?
Sure.
1 second. Just grab his inmate.
So basically, I got it.
Okay, so his inmate number is 289208.
Okay, so let's give us till Monday to be able to have him on Zoom.
Okay.
So let's say the 17th at 8:30.
Okay.
We'll handle all of it, everything.
Okay.
Thank you.
You're welcome. Thank you. I'm glad I found you.
Me too. Sorry, here's this case.
Have a good day, you and safe.
I didn't hear what you said.
I just said, have a great day, you and your staff.
Oh, thank you, you too. Thanks.
Bye.
Okay, Attorney Perkins, are you there?
You said, you ready for me, Your Honor?
Yes, I am. This is case 2356387, the people of the state of Michigan versus Demetrius Ewing, charged with count 1, controlled substance
Okay.
delivery.
It's,
Methamphetamine, count 2, weapons, felony firearms, set for an exam today at 9 o'clock. Appearances.
Good morning, Your Honor. Danielle Perry on behalf of the people, P85495.
good morning, Your Honor, and good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Ewing. Your Honor, I did think that this was a discovery update date, not an actually exam date, and that's.
I haven't found that there was adjourned for an exam today at 11 o'clock. I mean, at 9 o'clock on the 11th.
Well, the last time we were in court, you had ordered the, because it's not DPD, it's I think Sterling Heights and Comet, who are the agents who investigated this particular criminal activity, and they had not produced the discovery pursuant to the discovery order that was signed off on, I believe, by everyone in this matter. And that was what I understood this to be, was a check-in date for the discovery. I haven't received anything since the last time we were in court.
Okay, Ms. Parrish, do you have any, and I don't disagree at all, you probably are correct. I just have here adjourned 7, 11, 9 o'clock. Do you know if, first of all, any discovery has been provided?
No, and to update Your Honor, as I was reading through this because, and I apologize, I thought it was also set for an exam, so therefore I covered the exam. And I did reach out to the OIC because in the investigator's report, it indicates none in bold letters with video. I know we're not used to that here with CPT and whatnot, but as defense counsel has indicated, this is a Macomb County led case. And we have not only myself, but also one of the other APAs did reach out to the officer in charge just to confirm that and give an explanation as to why. Maybe they don't wear them. I don't know what the situation is going on over there in Macomb County, but we want to provide that to defense since defense did inquire. However, the officer in charge, and Officer Aaron Schmieder, did not reply back to our inquiries as to an explanation of why there is no video. It just indicates on it, the investigator's report that there is none. That is the only update I have, and if council thought that this was a PCC, people do not object to resetting this for another day this week. But I do not, again, we have not had any responses back from the officer in charge, and it does not appear that officer in charge is here today in court. So if you'd like to substitute defense and your honor, how you'd like to proceed at this point.
Okay, Attorney Perkins, I know in detail you explained exactly what you were looking for. Based off of Ms. Parrish's response, there's no. That's bad on. He just lost.
I'm sorry, Your Honor, my computer, my phone went out.
You're fine. I was just saying, based off, did you hear what Ms. Parrish said?
No, I cut out when she was getting in, she was saying some things and then it went out. I'm so sorry.
Defense counsel, to just summarize, and please feel free to ask any questions if I miss anything here. But both myself and the courtroom partner did reach out to the officer in charge to inquire for an explanation as to the investigator's report indicates that there is no video. And as you stated, this is not DPD, it's Macomb County. So we reached out nonetheless because of your order and your inquiry to find out why that is. We're not used to that here either. So unfortunately, we have not received a response back. We can only go based on investigators' reports and saying that there is none. As I stated to the judge, at this time, we have reached out and he has not replied back with an explanation. If you would, since you thought it was a follow-up probable cause today based on discovery, if you'd like to set this for an exam this week, we can go forward. Otherwise, we can, I don't know if your defendant is here. We can resolve it likely today, but the officer in charge has failed to appear today as of this time. So I cannot ask the person.
Right. My client should be there. But yeah, I think I see him there. what I would indicate is that, and I don't believe that you were the prosecutor who was there last. The judge ordered all of us to be there, and I was going to have a lawyer there, but that's why I checked in early to see if, because we got nothing. So he did say that there was no video, and the Michigan State Police, who were also involved, didn't have video, I don't believe. But there was a host of other things that he was supposed to provide, like activity logs, and there were some additional statements. There was some additional information about not necessarily the identity of the SOI. So there was a plethora of other things that he was supposed to provide. And with that failure, you know, that was the reason why I had chimed in prior to you getting on. It was a former prosecutor in the courtroom, I believe. I had made the representation to the court that I would be asking for a dismissal without prejudice. I think that in my own opinion, I just see these officers as doing this case the way that they want to do it rather than the way that the court has ordered it to be done. And consistent with what you have tried, when you reached out as a prosecutor, you know, you all are essentially on the same team. If you don't get any feedback, how are we able to be able to conduct a fair exam?
And I do recall from Mr. Kirker was the prosecutor last time. Attorney Perkins specifically went through everything. Now it's refreshed my memory that he needed or for them to even look into. And you're saying they haven't responded at all?
I have not received any response, and myself and Mr. Kirker initially in May reached out to him. And let's see here. Here's a little bit more information here, Your Honor. Because of the fact that because we believe I can double check with Mr. Kirker, but as you know, myself and Mr. Kirker are pretty good about putting notes into our files, and there is no updated notes from Mr. Kirker. And just to be forthcoming with the court and defense, because we thought it was an exam, Your Honor, we actually sent subpoenas out to the OIC. So
OIC's not here?
yes, Your Honor. So I would put him out, you know, to resolve this right now, but unfortunately he's not here. So that's why I said I would defer to yourself on this matter, how you want to rule.
Would you be prepared, the people be prepared today to hold the exam?
No, ma'am.
Oh, okay. All right.
May I make a motion, Your Honor?
Yes, you can.
Your Honor, at this time, I motion to dismiss this matter without prejudice. I would ask, and I know I do get that a courtesy is typically afforded to me by the prosecutor's office. If it is reissued, just to let me know, and Mr. Ewing will return.
Okay.
Defense counsel, without this matter resolved, I can tell you that I will not be requesting a reissue until this discovery matter is resolved. Now, if Macomb County reaches out to the warrant unit without my knowledge, I, as you know, I can't do anything about that matter. But I will put a note in the file that we do have an outstanding issue with discovery.
Okay.
Okay.
Thank you so much.
So with that, I would dismiss without prejudice for no complaining witness, and also because the additional discovery that was requested was never provided. There was no communication as to whether it even existed. So for both of those reasons, I'm dismissing without prejudice.
Thank you.
And Mr. Steve, since you are here in person, can you put your name on the record, please?
Sure.
Okay, your case is dismissed without prejudice. Huh?
I understand.
State your name again for the record. Okay. Thank you. So you're all set, Mr. Ewing, you can wait in the hallway, you bring paperwork.
Thank you.
We'll have this scanned over to you, Attorney Perkins.
Yep.
And
Thank you.
Attorney Rose, I know you've been waiting. Attorney Knapp, good morning. You have two cases.
I do, 9:30 and 10:30.
Is your 9:30 going to be a hold, do you know?
Well, I don't think it will, Your Honor, because I don't have to start all the discovery.
Today's discovery day.
Yeah,
All right,
on the bright side, I don't think the 10:30 will be good. Okay. So that's two of them I'm down here for, and not really gonna hold probably.
Okay, so I want to handle Attorney Rosenberg's last statement, and then I'll address it.
Yeah, I'm not even sure that Mr. Lewis is here.
Okay.
I did speak to him yesterday, he will be here. Oh, he is, okay, great. Thank you.
Okay, come on up, Attorney Rosenberg. Have your case now.
Should we have Mr. Wilbur Little with me?
If you want him at the table, yes.
Thank you, Your Honor.
Fine. No, scan it. That's it. Yeah. Okay, this is case 2357382, the people of the state of Michigan versus DeAndre Larry Lamont Wilburn Little, charged with count 1 weapons, firearms possession by a felon, count 2 weapons carrying concealed, count 3 weapons throwing firearms, set for example, their appearances.
Good morning, Your Honor. This is Dan Buchanan on behalf of the people, case number 86690.
Your Honor, may it please the court, and for the record, David Rosenberg, P 27407, on behalf of Mr. Wilbur Little, who's to my right, Judge, good morning.
Good morning. And sir, do you state your full name for the record?
DeAndre Larry Lamont Wilbur Little.
Okay. Ready to proceed.
Your Honor, it is my understanding my necessary witness is walking into the building as we speak.
All right, and this will be a hold in the event that the witness shows up in the next 5 minutes.
I have no, I'm at the pleasure of the court.
Okay, so I will give the witness 5 minutes.
Thank you, Your Honor.
Their interest. Is Attorney Hamilton present in the hallway?
No, ma'am.
What about Keita?
We just found out she's in custody, trying to see if they brought her over or not.
McKinney has some information. Good morning.
The jail is in lockdown right now. So
Keita, who do we have? Look,
she ain't coming over, Mr. Sean Thompson. Only two.
only two.
Yeah, Thompson, 2 cases.
Okay, so that,
Thompson is 2 injured most.
Okay.
well, did you hear what you just said?
Yes, sir.
Good morning, Mr. Warner. Good morning, Mr. Warner.
Good morning.
Hi, can I ask you what you're checking in on today?
I am on Mr. Winsett.
With that, no, yes. 2158454, the people of the state of Michigan versus, how do you say your first name?
Desire.
Denzel? Denzel with that, charged with count 1, reckless driving causing death, count 2, operating drag racing, count 2 is a misdemeanor set for an exam today. Appearances?
Good morning, Your Honor. Sarah Bill on behalf of the people, P84189.
Hey, greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556. So we move for mutual suspension.
Sequestration. Okay, this is getting ready to be a hold.
Yes, ma'am.
Okay, give me 1 second here. Before we do that, we have the county jail. I want to get the inmate off of there. Mr. Warner's on the phone. Just a second. Mr. Warner, did you find?
Yes, Your Honor.
Take.
I'm sorry.
My witness.
Okay, thank you.
Destiny Johnson.
Oh, I just logged her off. She did.
Oh, I'll tell her to log back on.
We still have counsel.
Spoke with the 11 voice message for attorney.
Okay, she's back. All right, nothing else is ready. Let's go back on the record. We're back on the record on it said case 2158454. And just for the record, Mr. Winsett is defendant number 2. If there's anyone, how do you want to do the sequestration, or do you want them in the waiting room?
Yes, Your Honor.
Okay.
Ms. Jones should be logging back in.
She's on here.
Okay, perfect.
Ms. Jones and Mr. Warner, I will be putting you all in the waiting room until you are called to be testified, if you are going to be called.
Okay.
Your Honor, can I approach on something before we start?
Yes, can I do the mutual sequestration order?
Oh, yes.
Is anyone on Zoom or YouTube who may testify as a witness on this case now they're trying to log off? If there's anyone in the courtroom who may testify or as a witness now they're trying to exit the courtroom? Is there an exception request for the?
Yes, Your Honor, we would ask for an exception for the officer in charge, Detective Kelly Alston, who's sitting to my left.
No.
And you want to approach our?
Yes, Your Honor.
Okay. The first witness, I want to clear up so the person on the iPhone, can you state your name, please? So the person who just logged on the iPhone in the car, can you state your name? Your phone is muted. Okay, man, we're getting ready to start an exam, so I'm gonna put you in the waiting room. I can't hear you. If you have an issue or you want to address the court, you can call 965-2406. Okay, you can call your first witness.
Your Honor, I do have one preliminary matter, if I may place that on the record. Your Honor, people moved for the mission of People's Exhibit 1, which is the postmortem report under MCL 76611BD as in Delta. Your Honor, we do have a stipulation between the parties for admittance of People's Exhibit 1 and for identification purposes that the deceased located at the scene in this case is Stephanie Brooks, and that is the body that was examined by the medical examiner for exam purposes only.
So stipulated.
And Your Honor, may I publish?
Yes.
Your Honor, if I may read into the record, the pertinent portions of this report.
Yes.
Your Honor, People's Exhibit 1 is entitled the postmortem report from the Office of the Wayne County Medical Examiner. It certifies that Dr. Lokman Sung, Assistant Wayne County Medical Examiner, performed a postmortem examination on the body of Stephanie Brooks at the Wayne County Medical Examiner's Office on August 26, 2020, with the ME case number of 20-12821. In the summary and opinion portion of this document, it states, it is my opinion that death was caused by multiple injuries sustained as a driver involved in a collision. The manner of death is accident, and the report is signed by Dr. Logan's son. And with that, Your Honor, people are ready to call their first witness.
Okay, just be admitted as exhibit, People's Exhibit 1, and you call your first witness.
Thank you, Your Honor. At this time, people call Destiny Jones, who is in the waiting.
Ms. Jones?
Yes, sorry.
Okay. I'm going to swear you in first. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Okay.
I'd like to put Mr. LaPenza in the waiting room while we are going through testimony. Mr. LaPenza, I'm putting you in the waiting room until your attorney appears to talk to you.
I understand, thank you.
Okay, whenever you're ready. Thank you, Your Honor. Good morning, Ms. Jones.
Good morning.
Ms. Jones, I'm gonna ask you a series, or can you restate your name again for the record?
Destiny Jones.
Ms. Jones, I'm gonna ask you a series of questions. If you're not able to hear me or you don't understand the question, just let me know, okay?
Okay.
Ms. Jones, I want to take you back to August 25th of 2020. Did something happen on that date that brings you in court today?
Yes, I got into a car accident.
Did that incident take place at Sherwood and East Outer Drive?
Yes.
And before you were at that location, where did you come from?
Home. Well, a block party. Before that location, we came from a block party.
Okay. And then when you eventually left that block party to go to Sherwood and Outer Drive, did you leave on foot or in a vehicle?
In a vehicle.
And what kind of vehicle was it?
A red Malibu.
And who is the driver of that vehicle?
Denzel.
And what's Denzel's last name?
Was it? If I'm pronouncing it right.
And say that one more time, the last name. It's okay if you mispronounce the last name.
Whitesett.
Okay, and who is that individual to you?
My cousin by marriage.
Okay, and where were you located at in the vehicle?
In the behind the driver.
And the driver is Denzel?
Yes.
Okay, and who else was in the vehicle with you?
My friend Alicia and I believe his cousin. It was a male that was in the front seat.
Okay, when you left that location, was there another vehicle that left the location with you?
Yes, it was a silverish gold car. I want to say it was full of females.
The driver specifically, what did the driver look like?
She was dark, if I'm not mistaken, she was dark skinned. And that's all I got. I don't really remember the driver too well.
Okay, and what is the vehicle? Is it a car, a truck? What kind of vehicle?
It was a car.
And when you leave that location, what if anything happens after that?
After we leave the block party?
Yes.
After we leave the block party, we started going towards my house.
When you say we started going towards, are you in a vehicle at this time?
Yes, I am.
The second vehicle that you're talking about, where's that vehicle located when you're driving?
They was behind us at first. Then when we got to the light, they was on the side of us.
And what if anything happens when you make the light?
When we passed the light or when we were sitting at the light?
When you were sitting at the light.
When we were sitting at the light, the females that was in the car, they was hype, listening to music, moving around a lot, revving their engine.
And what was the defendant doing in your vehicle?
He was listening to music and he was revving his engine back.
Okay. And then when the light turns green, what happens?
They both took off at high speeds.
And what if anything happens after that?
As we're driving up the road, I see the light that's ahead of us. It was green at the moment, then it went from green to yellow to red. And after that, we passed the light. It was red. We passed the light and we hit a bump, and that's all I remember.
When you say you passed the light, does that mean the vehicle ran the red light?
Yes.
No further questions, Your Honor.
Cross.
Ma'am, so you didn't see the actual crash, correct?
No.
Your statement was that you were at a party prior to this?
Yes.
Did you drink or smoke at that party?
Smoked, yes.
You smoked, what did you smoke?
Marijuana.
So it's fair to say at this time you were high?
Yes.
Ma'am, has there been any memory difficulty on your part
On,
This accident,
I'm sorry.
has there been any memory difficulty on your part since this accident?
No, not that I know of, no.
No further questions, thank you.
Nothing further. Okay, and just for the record, Ms. Jones is on Zoom testifying. There was
And I'm sorry, Your Honor, there is a stipulation between defense counsel and myself for Ms. Jones appearing via Zoom.
That's correct. That's so stipulated, no objection.
Okay. And is Ms. Jones free to exit?
Yes, Your Honor.
Ms. Jones, you can log off. You are all set for today to testify.
Okay, thank you so much.
Give me one moment. Yes, okay, who's next with this one?
Your Honor, at this time, people call Detective Kelly Alston Brown.
He's ready to tell the truth, nothing but
Yes, Your Honor.
the door opens in the front here.
Right here?
Yep.
Thank you.
Just make sure you speak up in the microphone when you respond to it.
Yes, Your
Thank you. Whenever you're ready. Thank you. Can you please restate your name again for the record?
Detective Kelly Alston Brown,
And where are you currently employed at?
Detroit Police Department,
And what capacity?
detective,
And in this case, what was your title?
detective,
Were you the officer in charge?
yes,
And were you employed in this capacity on August 25th, 2020?
yes,
Did you in fact work on that day?
yes,
Did your duties take you at or near East Outer Drive in Sherwood?
yes,
Is that in the city of Detroit?
yes.
County? And when you made that location, what if anything did you observe?
3 vehicle crash.
And what were the make and models of the 3 vehicles?
There was a red Chevy Malibu. There was a silver Buick LaCrosse and Honda Accord.
And Your Honor, if people would move to People's Exhibit 2, which is a traffic light video by way of stipulation between defense counsel and myself, for example, this is only.
So stipulated.
Okay, give me a minute, as people's exhibit number 2.
Thank you. And Your Honor, may I publish?
Yes.
Your Honor, may I have co-host? Yes, please. Detective Alston Brown, this video, what is this video from?
This is the intersection of Sherwood and East Outer Drive.
Okay, and then we're gonna look at the bottom left video. And I'm gonna circle it with my mouse, the bottom left video, or yes. What direction are we looking at here? What street is this?
That's the intersection right of Sherwood and Outer Drive. So it looks like Sherwood to me.
Okay. And I'm gonna start the video, I'm gonna pause it, I'm gonna start it at 9 minutes and 50 seconds. 9 minutes and 49 seconds. Same video, I'm circling it. What color is the traffic light?
I'm circling where, right here,
Yes, the bottom left, yep, right
bottom left. Red, traffic signal is red.
there. Okay, and I apologize.
Another circle.
And I'm gonna play the video from 9 minutes and 49 seconds to 10 minutes and 5 seconds. Apologize, Your Honor, there's a delay. I'm gonna stop the video at 10 minutes and 2 seconds. Looking at the same video, the bottom left, what color is the traffic light?
Red.
Thank you. I'm gonna continue the video until 10 minutes and 10 seconds. Stopping the video at 10 minutes and 10 seconds. Now we're gonna focus on the video at the top right, which I'm circling. You can kind of see there's a play. You know which video I'm asking about?
Top right, yes.
Okay, what angle is this now we're looking at?
Above, so that is is capturing the intersection of Otter Drive and Sherwood. So it's a top picture right now.
I'm gonna start the video at 9 minutes and 50 seconds. I'm gonna play the video until 10 minutes and 5 seconds, starting now. Focusing on the top right video. Your Honor, is there a delay on your screen? Yes. I'm gonna play it again, Your Honor, just because it was it was kind of choppy. Starting again at 9 minutes and 51 seconds. Okay, stopping the video at 10 minutes and 12 seconds. The last video is going to be in the top left-hand corner. Circling with my mouse. What view are we looking at right here? What's the street?
Sherwood.
Okay. Starting the video at 9 minutes and 50 seconds. Playing that until 10 minutes and 5 seconds. Okay, stopping the video at 10 minutes and 5 seconds. In this video that we just observed, is there a vehicle at the top of this screen?
Yes.
See that I'm circling? When you make this scene, what vehicle is that?
That's a silver Buick.
And what kind of damage was on that vehicle when you made the scene?
So it was like scuff marks on the right, the driver's side, rear of the vehicle.
Okay.
Scrapes on the bumper.
Now it's a little blurry, but I know you watched this video before. Is this a vehicle right here that I'm circling?
Yes.
Okay. When you make this scene, what vehicle is that?
Honda Accord.
What kind of damage was on that Honda Accord?
Heavy accident damage from the front to the back.
Okay. And then this vehicle right here that I'm circling that's closest to this traffic light. What kind of vehicle was that?
That's a Malibu.
What kind of damage was on the Malibu?
Severe, heavy accident damage.
Now, after reviewing the video, the scene, and the damage to the vehicles, were you able to make a determination on the two vehicles that go through the red light? Which vehicle was on the right hand and which vehicle was on the left hand side?
So the Buick was on the left-hand side, silver in color. And the on the right-hand side was a red Chevy Malibu.
Okay, and then the third vehicle that's involved, where was that vehicle coming from?
Outer Drive, East Outer Drive.
And did you speak to the driver of the Buick?
Yes.
What was that individual's name?
Last name of Corbin.
Did you speak to the driver of the Malibu?
Yes.
Do you see that individual in court today?
Yes.
Can you please point to that individual and state something they are wearing?
Bow tie, black bow tie, and blue shirt.
And Your Honor, may the record reflect identification of the defendant? So requested. And were you able to speak to the individual that was driving the Honda Accord?
No.
And why?
She was declared deceased.
Okay. And what was the posted speed limit on Sherwood?
30.
No further questions.
Detective, correct?
Yes, sir.
In your preliminary statement, isn't it correct that you indicated that that the silver car had crossed in front of the maroon car?
I'm sorry, can you restate that?
In your police report, did you indicate?
My investigator's report,
Yes, your
sir?
investigative report. Did
Yes.
you indicate that the white vehicle had crossed in front of
The white vehicle, sir?
the silver Malibu had crossed in front of the Burger King,
Yes, sir.
correct?
Yes, sir.
So it was actually, it was your test, it was your report indicated that the white vehicle was actually.
White vehicle?
I mean, the silver vehicle, the light colored vehicle
Yes, sir.
was in front of the burgundy vehicle. correct?
Yes, yes, sir.
And it's true that the light vehicle was not driven by Mr. Whitsett, correct?
You're right. It was not.
Okay. I want to direct your attention to the incident.
Okay.
I have to stand over here because there was.
Okay.
I believe it's taken down.
It kicked me off, but I'm trying to.
Oh, okay.
It shouldn't be.
I have IT. Keep it moving.
I'll send you. You gonna get paid.
I want to direct your attention to the left upper box corner. Yes, the top.
Okay.
I want to direct you, thank you, Madam Vice Chair. I want to direct you this at 10:02 in the video. No, the lower left.
Lower left.
Yes. Are you able to identify which vehicle Mr. Whitsett is driving?
I can't determine that until they go through the light, because you can't see what color either vehicle is, meaning just the headlights.
Okay, that's fair. And starting again in 10 minutes to 2 seconds.
The same.
We're gonna focus on the upper left.
Okay.
Right there. Now, could you identify, there's two vehicles there, correct?
Yes.
Can you identify which vehicle Mr. Whitsett is?
No, not from this video. It's very hard, you know, from this video here.
We're gonna play it from this point, which is 10:03, through this.
The same camera.
Yes, thank you. Can we rewind it short? You saw the crash, correct?
I seen the crash, but you gotta remember, this is going so fast. So
Could you tell there was a car that hit the decedent's car first?
you can tell there was an impact.
Can you tell there was one car that hit that car?
I can't tell.
Can we play it again?
Brought my laptop up to work too.
Maybe that'll help,
Okay.
unless I walk up to
Your Honor, may I approach?
Please, that's fine.
it helps the last thing. Okay.
And we're playing it from 9:50 on the video.
And
The upper left, which will show the actual incident. Okay, it's being played, I believe, at half speed.
yes.
Okay, it's half speed, so we slowed it down.
Okay.
And I want, once again, I want to have you focus on the upper left-hand corner.
Okay.
My question is still, I'm asking if you
I'm just
guys.
trying to first concentrate, then
I'm playing.
I want you to try to identify which vehicle hit.
by the time they come through the intersection, the collision has already happened, and it's just a ball of fire at that point. Because, you know.
But we'll go back to your original statement, when you said that the light car was the lead vehicle,
Yes,
right? And the light car had been in the accident, right?
no, I didn't say that.
The light car was in an accident, correct?
This accident,
And it was
yes,
in this accident,
yes,
correct?
this vehicle, yes, sir.
Yeah.
Yes, sir.
The decedent's vehicle, which side was the impact on the decedent's vehicle?
That whole entire car suffered from accident damage from the front, the driver's side, and the back, and the car caught on fire. So it would be, if I'm not mistaken, the right hand, the driver's side of the vehicle, of the Honda.
Where that side was inflicted most damage.
Yes.
Okay, now, how long have you worked in the police department, correct?
Yes, sir.
How long have you worked in the police department?
15 and a half years.
And what was your duty on this particular evening?
My duties was I responded to the scene and we processed the accident scene, my team now.
Okay. So, but you're not an accident and reconstruction specialist.
I am not.
You are not. You have any training in accident reconstruction?
Yes, AI from 1 through 7.
And what is that you can?
So what that is, that gives me the ability to be able to process car scenes, measure yard marks, see black box, determine various different things.
General things about accident.
Yes.
Okay, and in your investigative report,
yes,
you had indicated that the light colored vehicle was the lead vehicle.
Yes.
Yeah.
Can we clarify, there are 3 vehicles mentioned here. I have a red Malibu and a silver Buick LaCrosse.
Yes, Your
Was
Honor.
there testimony of what color the Honda Accord was?
The Honda Accord was gray.
Okay.
Older model.
And Your Honor, just for clarification, because for some reason I keep getting white and silver, we're referring to the light colored vehicle as defendant number 2, and the burgundy vehicle as my client.
Okay, but there are 2 vehicles that are silver and are gray.
And I refer to the decedent's vehicle as the decedent's vehicle.
I would object to saying burgundy. No one testified to burgundy as a color.
What-
Red. Red.
I'm sorry, Red.
Can we describe it as the vehicle? Because silver and gray, I still don't know which one you're talking about, we say light or.
Okay, I will clarify. So the vehicle in which I have described is light. What vehicle is that actually?
Are you referring to?
I'm referring to defendant number 2.
So that would be a gray Buick LaCrosse.
Okay, and the vehicle I refer to as burgundy. What actual?
That is a red Chevy Malibu.
And that is the vehicle that the defendant was driving, correct?
Yes.
And the decedent was driving.
Gray, late model Honda Accord.
Okay, okay, that's good. Now, in your investigative report, you indicated that defendant number 2's vehicle.
The Buick.
The
right?
Buick.
Okay.
Was the lead vehicle. Did you make conclusions as to the cause of the crash at that time?
I'm sorry.
Did you make any
repeat that?
conclusions as to the cause of the crime at that time?
No.
Okay. Now, this incident occurred in 2020, correct?
Yes.
How long did it take the investigation to conclude?
I can't recall.
Your Honor, I'm gonna object to relevance. Well, she already stated she can't recall, but any other question?
Well, okay, this is the turn on going down. This is a 2020 case. It appears that it wasn't brought until 2023, which I'm trying for the people to account for the delay in prosecution.
I'm gonna object to relevance, but I'm gonna also ask to approach, and I think everyone say on that.
Okay.
Approach it like. Before you move on, off the record, Mr. LaPinta.
Yes.
You tell the deputy to place you into a breakout room and accept the invite because your attorney wants to speak to you.
Should I take the camera with me, ma'am?
No, you don't have to go anywhere. You just have to accept the invitation to go into the breakout room.
Okay.
You have to hit okay or join.
Okay, I'm just waiting. Oh, I don't want to do this stuff. I'm sorry. I got breakout room I gotta go into, she's saying? All right, I don't know how to do that. Yes.
Okay, Attorney, oh, he's in the breakout room now. Okay, back on the record.
And one more follow-up question, Detective. Are you able to make a determination of which vehicle struck the decedent's car first?
Am I able to determine
Yes.
which vehicle struck?
The decedent's car first.
No.
Why is that? It was not from your investigation?
My follow-up investigation, yes.
And did you make a determination as to which vehicle struck the decedent's vehicle first?
Refer to my investigation.
We could help you.
Thank you. Thank you. Okay, I'm ready.
Was that, were you able to refresh your memory?
Yes.
Yes, back to my original question, were you able to make a determination as to which vehicle struck the decedent's vehicle first?
Yes.
And which vehicle was that?
So that would be the lacrosse.
The lacrosse. That's defendant number 2's vehicle, correct?
Yes.
Not the.
Oh, wait.
There's no question on the floor. So your testimony is that you made a determination that defendant number 2 initially struck the decedent's car, correct?
I misspoke.
Well, I'm asking questions.
Okay, I'm sorry. I misspoke. This was a 2020 case.
Okay, let me ask you a question.
Okay.
So she still hasn't been able to answer that question you asked.
I will re-ask it. Let me re-ask it.
Okay.
Were you able to make a determination as to which vehicle struck the decedent's vehicle first?
The Honda Accord, yes.
What was that based on?
Looking at the green light for one thing in the video.
Well, your previous answer was, you said lacrosse. Why did you say lacrosse?
Once again, this is a 2020 case. And I have to take my time to think about exactly what happened. This was a very large thing that we brought out the 3D scanner to measure. And as I watched, as I'm playing it back in my head as if it just happened, the Buick LaCrosse got through the light at Sherwood first. And that's how the damage from the right driver's side, damage was on the back. The 2018 ended up crashing into the Honda Accord. And you can definitely tell the difference because.
Well, I think you can answer our question. So your testimony is that the defendant's car was the initial car, initially hit the decedent's vehicle. Is that correct?
The 2018 Buick Malibu struck the Honda Accord.
First.
Yes.
Wait, okay. Buick Malibu, because it's a Buick LaCrosse and a Chevy Malibu.
So the 2018 red in color Chevy Malibu struck the gray late model Honda Accord. The 2012 gray Buick LaCrosse went through the light first, suffered accident damage of the rear of the Buick LaCrosse and spun out into the field. The 2018 red Malibu and the Honda Accord collided. The Honda Accord then blew up and caught on fire.
Understood. One moment. When did the car catch on fire?
I wasn't there when it caught on fire. When I arrived on scene, the car had just been put out on fire and was still smoking. So I wasn't there when it caught on fire.
Understood. One moment. No further questions.
You redirect, just briefly, Your Honor. Your Honor, I'm just gonna share my screen. And Your Honor, may I approach the witness with my laptop? Thank you. I'm showing you People's Exhibit 2 at 10 minutes and 3 seconds. I want you to focus on the top right-hand video. I'm circling it with my mouse. And I want to focus on the vehicle that's to the left. What color does that vehicle appear to be? Do you know which vehicle I'm asking?
You want to know what vehicle comes on the left?
No. What color
Okay,
does this vehicle appear to be in the video right here that I'm circling?
that's great.
Thank you. And then the damage to the vehicles. There's one vehicle that ends up away from the scene.
Yes.
That's the Honda, is that correct?
The one that ends up away from the scene is the Buick LaCrosse. It's spinned out and is in the field on the right-hand side of Sherwood.
Thank you. The damage on that vehicle, is it consistent with it being T-boned or smashed in?
Yes.
Leading question, Your Honor.
I'll rephrase, Your Honor.
Okay.
Let's go through the damage on the vehicle that's in the field.
The Buick.
The Buick. What kind of damage is on that vehicle?
So the damage is on the rear of the vehicle, the right side is scuff marks.
Scuff marks, that's it.
No, that's it.
Okay, no further
For
questions.
the lacrosse, correct?
Yes,
Buick
that's
LaCrosse.
great. Buick LaCrosse.
Yes, Your Honor. No further questions.
No redirect.
Okay. Sit down, thank you.
Your Honor, my next witness is Sergeant Paul Warner. He's appearing via Zoom by way of stipulation between the defense counsel and myself. Okay.
So stipulated. No objection. Yes, ma'am.
We're not accepting.
Nah, actually, it's about the prisoner's over,
They did bring.
but the Thompson A1 case is gonna be dismissed, so there is no contact with plaintiff. Thompson's here. And as far as, Kita Yaya, her attorney is still not here, Judge.
And you also have 2 adjournments too, Judge.
Okay, we're just gonna wait till after this. All right, let me break. Mr. Warner, you can unmute your device.
Yes, Your Honor.
Can you answer right now? We're gonna swear you in. You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Can you please restate your name again for the record?
Paul Warner,
And where are you currently employed?
Detroit Police Department,
And for how long?
27 years.
Were you employed in this capacity on August 28th of 2020?
Yes, I was working.
And did you download the CDR report for a vehicle in this case?
I did.
And what is the CDR report?
That's a crash data retrieval report that is related to the event data recorder within a vehicle.
Okay. And how many times have you downloaded and reviewed reports like the one in this case?
Hundreds.
And what other experience and training do you have regarding the CDR reports?
I've taken a course through Michigan State traffic safety program to use as a technician, and I'm also an analyst to actually analyze the reports.
Okay. Okay. So stipulated, as to witness Paul Warner's expertise in.
Sergeant Warner, what would I put you as an expert in?
The court has deemed me an expert in crash data retrieval, if that is what the court is wanting to do in this case.
Thank you, Sergeant Warner.
Based on stipulation, yes.
Thank you. Mr. Warner, what kind of vehicle did you report or did you pull a report from?
I believe it was a Chevy.
Do you have that report in front of you?
I have a copy that was sent to me by yourself.
Okay. And did you get an opportunity to review that report?
I did. It's a 79-page report.
And does that report fairly and accurately depict the data that you downloaded in this case?
Yes, it is the same report.
In your honor, people would move to admit People's Exhibit 3 into evidence.
Okay.
Okay, it'll be admitted as People's Exhibit number 3.
In your honor, may I publish?
Yes.
And Sergeant Warner, can you look on page 1 of that report? And can you state the vehicle that's listed on there?
It's a 2018 Chevy Malibu.
And I'm going to turn your attention to page 64. I'll give you a minute to get there. When you're ready, just let me know.
I am at page 64.
From this page, were you able to make a determination on how fast that vehicle is going 1 second before impact?
There is a speed recorded at 1 second. This is the third record. The second record is the one I was focused on during my analysis.
Okay, are you able to make a determination from the third record? From page 60?
This one is incorporated. Record 3 is incorporated into record 2. Record 2 occurred first.
Okay, so if there was an incident, what's the last incident that took place?
Let
me re-ask this, I'm sorry. When there's records, how many records are on in this report?
This one shows 3. My analysis shows that the first one was an older record, and the second and third are related.
And ask just some follow-up questions. When we say record, what does that mean?
That's what this report is indicating, is based off events.
Okay, so there's a certain amount of events that the car stores?
An event is classified as an airbag deployment or a non-deployment event.
Okay, In this case, which event should we be looking at then?
Record 2 is the first event related to this incident.
Okay. And I'm sorry, Sergeant Porter, do you have a page number that we should be looking at?
Yes, just 1 second, please. Page 43 would be the similar page of record 2 that you just had me go to as 64. So 43 is what I looked at.
Okay. So I would, and this would be the last event, meaning this would be the event that happened right before the collision. Is that correct?
This is the event, this is the record prior to the event, which is a deployment event. Record 2 is. It's the first of the 2 events in this incident.
Okay. Are you able to state what the speed was 5 seconds before impact?
Yes, this record goes back 5 seconds.
Okay, and what was the speed?
The speed at 5 seconds was 72.7 miles per hour.
And what about 0.5 seconds before impact?
0.5 seconds prior to the event was 82.6 miles per hour.
Thank you. No further questions.
Sir, did you do any more did you do any other speed analysis on any other vehicles involved in this incident?
I don't recall if I did or not, sir.
Did you do a speed analysis on the vehicle across?
I wasn't provided the report related to any other vehicle other than this one for preparation today.
So your report only is as to the vehicle you just testified to, correct?
I was asked to testify to this crash data retrieval report related to the Chevy Malibu.
Okay, you have no other information on no other vehicles involved in the crash, is that correct?
Well, I don't have it in front of me. The officer in charge would have the file, and from my memory, I cannot tell you what results or downloads I did in relationship other than this one.
All right, very well. No further questions.
No, Your Honor.
Okay, you're all set, Mr. Warner.
Thank you, Your Honor.
Yeah, I don't think it was based on the record either. Witness Warner was on Zoom manipulation.
Yes, Your Honor.
Okay. Any other witnesses for the people?
No for the witnesses, Your Honor.
Any defense witnesses?
Oh, I'm sorry, Your Honor.
Any defense witnesses?
Oh, no.
Okay. Let's see. No one's on the page to begin argument.
Your Honor, people were respectfully request bind over on all the charges or reserve argument.
Okay.
Your Honor, obviously this is a question of fact. I would just place my objection just going forward as this is a 3-year-old case and it's prejudice my client, and we just about forward now. 3 years later.
And we discussed the sidebar of the issue. I believe it'd be best address the motion.
Understood. I just want to make a record. Thank you.
Your Honor, the court heard her testimony from Destiny Jones. She stated that she was a passenger in Mr. Whitsett's vehicle, that there was a second at the scene, that they both take off at a high rate of speed. There is a red light and both the vehicles pass through that red light. We heard from Detective Kelly Austin Brown. She states that she observes 3 vehicles, that the defendant is the driver of the red Malibu. The court reviewed video. The video that I showed last to Detective Kelly Austin was at 10 minutes and 3 seconds, and you can clearly see the vehicle on the left-hand side, silver in color. We also know from Detective Kelly Austin that the damage to that vehicle is minimal. I believe she testified there's scuff marks. This is consistent with an individual not having a collision with a deceased vehicle. The court also heard testimony from Sergeant Paul Warner stating that the defendant's vehicle was driving over 80 miles per hour in a 30-mile-per-hour street. And Your Honor, because the two vehicles are driving side by side, they leave the same location, they're both revving their engines before they take off at a red light, they both pass through a red light. This is probable cause evidence that the individuals are drag racing. Because they are drag racing, excessively speeding, and running a red light, this resulted in the death of Stephanie Brooks, and therefore people are respectfully requesting a bind over on the charges.
Okay, I do believe that this is a question of fact of the trier fact. The people have met burden of proof today to satisfy the one count of reckless driving causing death. Three witnesses that the people presented, they were advising you to satisfy the elements required of the probable cause standard. First, the defendant drove a motor vehicle on a highway or other place open to the public or generally accessible to motor vehicles. In this case, there's testimony from Destiny Jones, who testified that there was, actually she didn't identify the defendant, but said that the person in the vehicle in the red Malibu was driving on Sherwood and Outer Drive, in which Detective Kelly Austin Brown in the video also showed that the vehicle was being driven on a highway or place open to the public. Second, that the defendant drove the motor vehicle in willful and wanton disregard for the safety of persons or property. Willful or wanton disregard means that more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risk to the safety of people or property. And through the third witness, as well as the video that shows extensive damage from the Malibu and the Accord, about 0.5 seconds before the impact to the vehicle that the defendant was driving was reported to be going 82.6 miles per hour. Third, the defendant's operation of the vehicle caused the death of the decedent. And to cause the death, the defendant's operation of the vehicle must have been a factual cause of the death. That is, but for the defendant's operation of the vehicle, the death would not have occurred. In addition, death must have been a direct and natural result of operating the vehicle. Through the Exhibit 1 from the post-mortem report from the medical examiner, as well as through the testimony of Destiny Jones stating that both cars drove off and sped from that light to the next intersection to a crash, and due to testimony from the detective stating that there was minimal damage to the cross, was the third vehicle in the incident. She stated that there was minimal damage and the cross passed through the intersection first. Testimony that there was severe damage to the Malibu Accord, and that the decedent's vehicle even caught on fire, satisfied the probable cause standard to show that the defendant's action did cause the death of the decedent in this case. So with that, bound over Mr. Wilburn Little to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date 2 weeks from today, since we're not in custody. So that will be July 25th at 9:05 a.m. Bond is continued.
Your Honor, if I may address this topic.
Please.
Your Honor, as I indicated, this incident happened well over 3 years. Oh, we just want to remove this topic.
And Your Honor, there's a co-defendant in this case, if your child was removed as well, and in this older case, I have no preference to being removed.
Thank you, save your time. Let me I'm sure it is not stated in your bond conditions, you are not to drive any vehicles, operate any type of vehicle with a motor, but I will tell it for the request of council and no objection for the people.
Very well, thank you.
Thank you. You're welcome. And you're all set, sir. You can wait in the hallway for your turn. Attorney O, have you had an opportunity to review the tether violation report?
I have, Judge.
Okay, are you ready to go on the record? Yeah.
Yes, Judge.
Okay. There's no prosecutor in the courtroom. Give me a moment. Oh, I'm sorry. Not an attorney. Yeah, that's right. Let me. Okay, this is a tether violation not on the docket. People of the state of Michigan versus Michael LaPinta. Okay, 2305681201. Appearances.
Good morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Morning, Judge. Neighborhood Defender Service by Glen O, P 83424, appearing on behalf of Mr. LaPinta, who's present via Zoom. Mr. LaPinta, please state your name.
LaPinta, Michael.
Okay, Attorney O, you had an opportunity to review the violation report. Is that correct?
That's correct, Judge. Mr. LaPinta and I have had an opportunity to review it. We are ready to admit to the violation with an explanation.
Okay.
I'm sorry, Judge, I couldn't hear you.
Oh, I'm sorry. I said go right ahead with the explanation.
Thank you, Judge. In speaking with Mr. LaPinta, he wants me to lead with, number one, that the reason he's currently unhoused at the moment is because the incident location was his residential address. So after he caught this case, there was a stay away order and witnesses who also reside at that address. So he temporarily changed his address to his brother's address. Unfortunately, they had a falling out, so he became unhoused again, and he didn't have a phone, so he couldn't get a hold of his tether agent. His tether agent was able to locate him on 7 Mile and Mound, and when his tether agent came to pick him up, he was very cooperative and flagged his tether agent down. He had no intention of running. He was coming to the court date on the 13th. While speaking with Mr. LaPinta in the breakout room, he provided me with 2 numbers, both supervisors at work, and Joe Richard confirmed that they do have a address for him to be released to. So we're asking the court to reinstate his original bond and release Mr. LaPinta.
Okay, any objection from the people?
As long as they approve of that new address, no.
Okay, Attorney O, you have those addresses, correct? Or that address?
I have their number and address.
Okay. As long as you provide that to tether unit. Let's see here. You put it in the chat as well, and I will reinstate the bond.
Yes, Judge.
Thank you.
LaPinta, you can log off. I'll reinstate your bond with the new address and where you are to be housed.
Thank you. I'll see you on the 13th. Thank you very much.
Welcome. Have a good rest of your day.
Okay, thank you. Thank you, Your Honor.
You're welcome.
Hopefully I go home soon.
Thank you.
Okay.
Hey, how you doing, y'all?
Trying to get through today.
How you doing?
Huh?
Pretty smooth today.
A little jammed up today.
Feel like that subject.
Yeah. Okay, you have, who you have?
I have Georgiana Lewis. It's gonna be a German, I understand. I'm standing there for Aaron Ogletree. It's the 10 o'clock.
Oh, okay, all right. And you have attorney Barnwell.
Yes, Judge, she's in the hall.
Okay, that's the code of everything.
Oh.
Mr. Thompson is here also, Mr. About the other others. And is the witness here on Wilburn?
Yes, Judge, you got two state troopers.
Okay, that'll be next after. We'll bring your mic.
Thank you, Your Honor.
Oh,
I'm standing there for Aaron. This is Cody.
oh,
Aaron
Cody,
Ogletree.
okay, I didn't.
It's gonna be adjourned, I understand, I guess.
Well, good.
I think the officers in training. Right here, right here.
Oh.
Okay, we are on the record. This is case 2357406, the people of the state of Michigan versus Tashawn Jamar Thompson, who is defendant number 1. And Janisha Ashante Lewis, who is defendant number 2. Both are charged with count 1, weapons carried concealed, count 2, police officer assaulting, resisting, and obstructing, and count 3, weapons from firearm, set for exam today. Appearances.
Morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Tashawn Thompson. My P number is 42505.
Morning again, y'all. Edward Taylor here on behalf of Ms. Lewis, P number 57166. I'm appearing for behalf on behalf of the attorney of record, Aaron Ogletree. Is that what your permission?
Yes, Mr. Mayor. You state your name also? Okay, and Mr. Thompson, can you state your name, please? Okay, what are we doing today?
So the people are not prepared to proceed at this date and time. In my initial order, I had indicated that an officer would be unable to attend due to a mandatory training he was in today. That officer has appeared today, but A second officer has called in sick, who was also necessary to proceed in this case. So different reasoning, but same conclusion. The people are requesting an adjournment.
Okay. Is there an objection from defense at all?
Your Honor, I'll respectfully move to dismiss on behalf of my client.
And I would join in that dismissal.
Okay. I do find good cause as there was notice provided before today regarding a witness not being available. And if the defendant were to call in sick, I would allow for adjournment as well. I can't control people's illnesses. So with that, we needed another date. Have you all discussed the date at all? You all have to discuss the date.
Do you have a preference on what day of the week, Your Honor?
Since the co-defendant case, Tuesday, Wednesday, and Thursday in the afternoon.
Are you talking about this week?
Well, I'm here every day. I just want to know what days you are.
Is the person still gonna be sick this week?
I don't have any indication as to the time frame that will be returning. Oh, I see.
I suggest 2 weeks, Your Honor, 25th.
Now I'm in trouble. Well, 1 second, let me see.
Yeah, you all can just talk on the date because we are pretty.
The 25th is good.
No, bad. Jury trial, Judge Kevin Cox.
What about the August 1st?
August 1st is open.
Can we do August 1st, Your Honor? Is August 1st?
Payments to be charged to the people. Returning to August 1st. Can you all do 9 o'clock? I know I don't have anything on the docket for 9 o'clock.
Yes, that's fine.
That's always a little tough because I always have to zoom in very a bit.
9:30?
Yes, yes.
Okay.
Thank you, Your Honor. Have a good day.
Let's see. Mr. Thompson, in on this case?
I'm not sure if he's in on this case or the other case, which is scheduled for today. So I was gonna ask, I'm not sure about the bond for this case.
It's 75,000, 10%.
This case?
No.
Or for the other case? Oh,
25,000 first. Okay.
okay. All right, so I'm not gonna touch that one.
Okay.
That's good. Thank you, Your Honor.
You're welcome. And for the second Thompson case, 2357333, the people of the state of Michigan versus Sean DeMar Thompson, charged with counts 1 and 2, assault with intent to murder, count 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation, count 4 and 5, assault. Count 5, assault with dangerous weapon, police assault. Count 6, assault with a dangerous weapon, police assault. Count 7, 8, 9, 10, 11, and 12, weapons, assault, firearms, set for example.
Good morning, Your Honor. This is Dan Buchanan on behalf of the people, P number 86690.
Good morning, Your Honor. Wendy Barnwell on behalf of Mr. Thompson. My P number is 425.
And are the people ready to proceed today?
Your Honor, the people are not prepared to proceed at this date and time. Necessary witness recently had a death in the family. She is planning a funeral, was not able to attend today.
Anything from the people, from defense?
Your Honor, we would respectfully move to dismiss this matter.
And we would request an adjournment, Your Honor.
Okay, The difference is planning versus being at a funeral. Do you have any more information other than she's planning a funeral?
That's the extent which I am aware of this time, Your Honor.
Find it out.
I discovered this last night at 6:30 p.m.
These are serious charges, but there's still no witness. If she was at a funeral, it would be different, but planning, I'm not sure what that entails, or she couldn't show up to court today without any more information or details. I'm just missing without prejudice. And what that means is, Mr. Thompson, your case can be reissued if the people wish to recharge. Do you understand that? Anything else?
No, thank you, Your Honor.
No,
Thank you
Your
very much. They don't let you up here, they let you up
Well, let me, this is a quick business.
Okay.
Good morning. 357-453, people of the state of Michigan versus Shonda Nicholson, charged with one count of assault for dangerous weapon, felonious assault, set for example, and appearances.
Good morning, Your Honor. This is Dan Buchanan on behalf of people, number 86690.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter Jonathan Roberts, P 86428, on behalf of Ms. Nicholson, who stands behind me. Ms. Nicholson, could you please state your name for the court?
Now, people ready to move forward?
Give me just a moment. Your Honor, the people are not prepared to proceed today. The complaining witness has indicated.
On that basis, we're moving to dismiss.
Okay, I will dismiss without prejudice as the complaining witness does not appear to decide which prosecute.
Thank you, Your Honor.
Thank you, Your Honor.
Segura here? Attorney Roberts, is Attorney Segura in the hall?
I
I
can
just saw her
check, she
walk
was
by.
here, so I can check.
Thank you, sir. Yeah, what do you have? What is this?
Your Honor, we're gonna need to adjourn the exam.
Okay, I'm sorry, just.
No, you've got a madhouse going on.
Yes.
I'm fine. Mr. Lewis. Oh.
357-496, people of the state of Michigan, Robert Lee Lewis, charged with count 1, weapons carried concealed, count 2, weapons, firearms, possession by felon, count 3, weapons, felony firearm with habitual offender services, notice is set for exam today.
Morning, Your Honor, Daniela Parrish on behalf of the people, PA 5495.
And good morning, Your Honor, Leslie Knapp, P 34696. On behalf of the defendant, Robert Lewis, who stands to my right.
Mr. Lewis, state your claim.
Robert Lee Lewis, third.
Okay, what's going on today?
Your Honor, we were here for a PCC on June 30th. Later that day, I did ask Mr. Selwaki, the APA that was here that day. I did send him an email asking for
video from the scout car and documentation that the DPD body cams were not working that day. He indicated to me he looked into it. I do understand from Ms. Pasek that, Parrish, I'm sorry. That Mr. Sawaki has been ill, so we have no response to that request, so I am requesting an adjournment, or I guess the people are, in order for me to get that discovery. Actually, please don't put it down. I request.
No, it's the people's request, and Mr. Sawaki is ill. I do know
Yeah,
that.
that's right.
So, she, defense counsel, off the record, Your Honor, indicated to me because the reports indicate that there is no body worn camera, she has specifically requested scout or dash video, and or activity logs. I have spoke to the OIC out in the hall, and indicated to her if nothing else, we need an explanation as to why, if there is no scout or dash video, why that is, and we need it sooner than later. So this adjournment can be very brief, Your Honor.
Next week?
Yes, sir.
Well, no, they haven't.
Well, if it works for defense.
Any day was the 18th, didn't have it.
I could do it on the 21st. Yes, okay, next week. The following week I could do on the 26th or the 25th.
Your Honor, I don't want to hold up the court any longer than necessary, since I already spoke to the OIC. They're well aware that we need this.
The 21st at 9 o'clock.
Thank you, Your Honor.
Perfect. It's a week from Friday.
So, sir, your exam has been adjourned to the 21st at 9 o'clock, back here in person. Okay?
Sure.
Thank you, Your Honor.
For the last time.
Oh, it's my pleasure.
Attorney McRipley, good morning.
Good morning, Your Honor. I have a issue with Mr. Jimerson's case. So I zoomed in. I have it on my calendar for 11 o'clock, but I just reread my notes and it says 1:30. I was wondering, Judge, I have to be in 3 courts in Oakland County this afternoon. I was wondering, and we've already adjourned this a couple times for the prosecution. I was wondering if would the court consider an adjournment, but there's no way I could be there at all until maybe 4 o'clock.
Well, 4 o'clock is not gonna work for anybody. I can tell you that now. For Jimerson, our 1:30.
I understand that, and I appreciate defense coming, calling us now. I can reach out to indicate, as defense has indicated, since there has been an adjournment on our part, I will not object to an adjournment at this time if defense needs.
Okay, so what I'll do is off the records, we'll get another date and Ms. Parrish will call the witnesses for 1:30.
Okay, yeah, the court's not available tomorrow, is it?
I think it'll depend on whether the witnesses will be available.
When?
Tomorrow.
Oh.
After the same time, 1:30?
Unfortunately, I cannot, the people cannot. I actually have training tomorrow afternoon. And I would rather give the witnesses a few days, just in case, if you have any other time early next week, so that we can give them a few days.
I understand.
We'll
I
discuss
understand.
that.
Thank you, Your Honor.
I understand. Thank you, Your Honor.
Welcome. We just need a date. Okay, back on the record. 2357382, people of the state of Michigan versus DeAndre Larry Lamont Wilmer Little. Appearances.
Morning, Your Honor. This is Dan Duquette on behalf of the people, P number 86690.
Your Honor, may it please the court, David Rosenberg, P27407, on behalf of Mr. Wilborn.
And we called this case earlier, but your witness, the people's witness, was not quite here yet.
That's correct. He has since arrived.
Hour and a half later, court's ready. You ready to call your first witness?
Your Honor, is there a necessity to sequester?
Yes. Just in case. If there's anyone on YouTube or Zoom who may testify as a witness on this case, now's your time to log off. Same in the courtroom. If there's anyone who may testify as a witness on this case, now's your time to exit the courtroom. Any other preliminary matters?
Yes, Your Honor. It's people's understanding that the defense has stipulated to a certified copy of the register of actions for exam purposes only, and that on the date of this incident, defendant in this case was not eligible to own, use, or possess a firearm.
Is that correct stipulation?
I was shown an ROA, Judge. If it's correct for purposes of the exam, the people have my stipulation.
Does it have a seal on it? Okay. I will admit it as people's exhibit 1 for exam purposes.
Thank you, Your Honor. That's all from the people.
Okay, call your witness.
The people would call Trooper Edwards to the stand.
After, give her your name, I'll start your witness.
Your Honor, I'm sorry. Before Ms. Trooper Edwards takes the stand, there's 2 final preliminary matters I forgot to address.
Regarding.
Additional
No, directly.
Right, because can't do both. Okay, take his name down and then we'll go back on the record and possibly have to excuse witness. Thank you. Step on the hallway.
All right. My apologies, Your Honor, I just got lost in the shuffle this morning. If the proof show, the people intend to add 2 additional counts, those being count 4, felon in possession of ammunition, contrary to MCL 750.227F6, and the associated felony firearm with that charge, contrary to MCL 750.227B.
Attorney Rosenberg, do you want a moment to speak to your client?
I have nothing to say at this point.
Okay.
Thank you. Thank you.
Okay. Bring it back in. Thank you. Make sure you speak up in the microphone.
Your Honor, if I may,
Yes.
ask the witness to speak up. I bought my hearing aids at Walmart.
Okay.
Thank you.
Trooper Edwards, can you make sure you speak up? That's very difficult in the courtroom.
I got you. I will.
Thank you, Trooper Edwards. Could you please state your full name for the record, please?
Trooper Marquis Edwards,
And Trooper Edwards, where are you currently employed?
with the Michigan State Police.
Okay, and what capacity are you employed with Michigan State Police?
So that's true.
And were you employed in that capacity on June 5th of 2020, excuse me, June 9th of 2023?
Yes.
And did your duties as a state trooper take you to the address of 5030 Whitfield near Beechwood Street? Yes. Is that the city of Detroit and county of Wayne? Yes. What is at that address? It's a residence district. Okay. So did you see anything at or near that address that brings us into court today? Yes. Okay, tell me what you saw that brings us into court today. There's a vehicle, white Chevrolet public travels north on Ridgefield. Ran the license plate of the vehicle. License plate on the vehicle listed EIV equals no evidence of insurance response. Okay, so let me stop you there. So at this point, you have run this license plate, and where did you run it through? We ran it through our lien, law enforcement information management system. Okay, and lien return, say one more time for me. EIV equals no, which is a no evidence of insurance indicator. Okay, so after learning that per lien, there was no evidence of insurance associated with this vehicle, what did you do next? Behind the vehicle began to back into the driveway. We activated our patrol car lights and initiated a traffic stop. The vehicle continued to back into the driveway 5030. Okay, so this vehicle was on the street, began backing into a driveway.
Your Honor, there's no necessity to repeat the testimony, Judge.
So after you activated your lights, did you make contact with the driver of that vehicle? Yes. Okay. So do you see the driver of that vehicle in the courtroom here today? Yes. Could you please point to them and identify them by an article of clothing they are wearing? I sit over there next to this attorney with a plaid shirt, long hair. Your Honor, may the record reflect he is identified in this case. So after making contact with the driver of the vehicle, is there anyone else in the vehicle? No. Okay. So what steps did you take after approaching that vehicle? We activated our lights, the vehicle continued back into the driveway, and we exited our patrol car and approached the vehicle. The driver immediately exited the vehicle. We instructed him to get back into the car. He insisted on, conducting the traffic stop outside the vehicle.
Sir, again, Troop, if you could speak up and speak a little slower, please.
If you could please restate what you just said a little bit more loudly and a little bit more slowly. My partner and I, after initiating the traffic stop, my partner and I exited our patrol car and approached that vehicle. As we approached the vehicle, the driver of the vehicle immediately exited his vehicle. We instructed him to get back into the vehicle. He insisted on conducting the traffic stop outside of the vehicle. He then, on his own. Let me stop you before you continue past this point. So he steps out of the vehicle, and when you make contact with him, do you get this person's name? Not immediately, no. Okay, did he indicate what his relation to that address was? Not immediately. He as the investigation continued, all those things came out. Okay, did he indicate that he lived at that address? He indicated that house was his child's mother's house and that he didn't have any insurance on his vehicle. So he indicated that he did not have insurance on that vehicle. What steps did you take after that? He was subsequently handcuffed, pending further investigation, and brought over to our patrol car. He gave us consent to search his vehicle. I asked him,
I'm sorry, sir, he did what, sir?
He gave consent to search his vehicle. So after he gives consent to search that vehicle, do you in fact search that vehicle? I do. Okay, and what do you discover in that vehicle? I discovered a loaded .380 caliber. Well, let me back up. So you discovered a firearm, and what type of firearm was it? Was it a rifle? Was it a pistol? I discovered a firearm, a loaded .380 caliber pistol, handgun. And you described it as loaded. How did you know it was loaded? It had live rounds inside of the firearm, which I unloaded and made the firearm safe. No further questions at this time.
I have a question. Sequence wise.
Please, Your Honor.
That has been given consent to search. When did he give consent to search? At what point? Was it skipping? What happened? I'm not sure. If you could actually clarify, I don't.
Certainly. Trooper Edwards, you indicated that at some point, the person you have identified as the defendant in this case gave consent to search his vehicle. Where was that car located at that time? The car was located, it was parked in that driveway when he gave consent to search the vehicle. I see. So this was after he had already stepped out of that vehicle? Correct. There you go.
Did you ask him yourself?
Yes.
I'll let you cross.
All right, so I can just cut Chase. when you asked consent to search the vehicle, my client was in handcuffs.
Yes,
Was he already seated in the back of your patrol car?
no,
So he was not free to leave.
not at that time, we were still investigating the.
No, I appreciate that. Actually, I should be more clear. If he had chosen with your police handcuffs around him to walk away from the scene, was he free to leave?
No,
And was he free to leave at the time you asked for consent to search the vehicle?
no,
Was the car otherwise legally parked in a residential driveway on Whitfield Street in the city of Detroit?
yes,
He chose to conduct whatever colloquy he was going to have with you outside the vehicle. Is that a true statement?
repeat that,
He chose to have a conversation with you outside the vehicle rather than staying in the vehicle. Is that a true statement?
correct,
That's not illegal, is it?
no,
At some point in time, someone in your patrol vehicle made an observation based on a license plate check electronically that there was no insurance on the car. Is that a true statement?
correct.
And when did that determination take place vis-a-vis this car backing into the driveway of that residential house on Whitfield?
I don't understand about.
Sure, okay, I'll back it up. When did you first make contact? What kind of car was the fellow driving?
An Impala Chevrolet.
What?
Chevrolet Impala.
When did you first see this Chevrolet Impala? Where was your patrol car? Where was the Impala?
I was behind his
You don't
vehicle.
know where physically on the street was on Livernois, was it on Grand River, was it on Southfield Road? Where was it?
I don't recall exactly where I originally saw the vehicle that time.
Well, you chose to run a license plate. Yes,
Yes,
just because? When you observed this the vehicle, the Impala, it wasn't being operated in some manner that was dangerous, when it wasn't being driven recklessly. True statement? Wasn't being driven carelessly.
no,
It wasn't speeding. Well, you made all those observations. What street were you on when you first made those observations?
Whitfield Street.
Whitfield Street.
Yes.
You didn't make those, is Whitfield a side street in the city of Detroit, a resident? What are the main streets, Trooper?
It's near Beechwood and Whitfield. It's near
Is
Beechwood
Beechwood
Street.
like a main street, 4 lanes, lights, side, stuff like that, or is it a side street as well?
It's a side residential street.
Okay, what were you doing on that side residential street?
Patrolling.
Is that something that you're normally tasked to do, is patrol side streets?
Your Honor, that's relevant.
No, it's real relevant, because I want to figure out how Trooper came into contact with the only car that was in existence at Beechwood and Whitfield, having not followed it there. I just don't, I don't get it. You're on patrol on, may I ask that question?
Yeah, I will allow.
All right, you're on patrol on, what was the street, Whitfield and what?
Near Beechwood.
Okay. Is Beechwood? How'd you get to Beechwood? What was your road of travel?
I don't know exactly where we're driving. Patrolling within the city of Detroit.
And how much observation did you make about this license plate that Impala? That's a bad question. How many houses off of, what is it called, Whitfield and
Beechwood.
Beechwood? How many houses off of Beechwood is this house on Whitfield that this Impala back in? 3, 4 houses?
I don't know off the top of my head.
Well, I mean, you had to have time to make a police electronic inquiry using your computer to find out if there was a bad plate.
Correct.
How long does that take?
Seconds.
Seconds. So you made the observation, then took a few seconds, and then determined it was a bad plate. And by the time all this has happened, the car's back into the driveway, yeah?
We got the, there was no indication prior to the vehicle backing into the driveway. We activated our lights as the vehicle backed into the driveway.
You didn't see the license plate until the vehicle was back into the driveway?
No, that's not what I
Is
said.
that what you're saying?
No, we got the indication behind the vehicle as the vehicle was traveling north. As the vehicle began to back in, that's when we activated our lights. So we already had the indication prior to the back.
Okay, for how long did you have that indication? My question is what I'm trying to get to.
Second.
1 second, 2 seconds, 3 seconds?
I don't know exact amount of time.
All right, in the meantime, car backs in the driveway. It's a true statement, sir. If I were to take a look at your dash cam or body worn camera, it looks like the person operating that vehicle is out of the car before you. Is that a true statement? That's bad image. It appears that the fellow driving that Impella was out of his car before you fellas were out of your patrol vehicle. Is that a true statement?
I don't recall.
I'm sorry?
I don't recall who got out of the car.
Well, it's sort of, all right. And what's the first thing you said to the fellow that stepped out of the car?
Asked him to get back in the vehicle.
Why?
Just wanted him to get back in the vehicle. My training experience in the vehicle. A lot of times individuals try to get away from, evade the traffic stop, try to evade.
Well, if you wanted to evade, you don't think you have a better chance shooting away in that Impella than walking away from it?
People run on foot as well.
Okay, but you didn't know this. You didn't know anything about this fellow except there's a bad thing, am I correct?
Correct.
So you want to get him back in the car.
Correct.
Possibility that car, I'm sorry, let me ask you another question. When you come up to somebody in a car and you're investigating, isn't it your policy and procedure to get them out of the car to check for offensive weapons? Could pose an issue of safety to you and matter people of public. You got them down. Isn't that the first thing you do?
Can you repeat that?
Yeah, sure. Come on back down. Trooper. Did you ever pat the fella down?
Yes.
Where, did you do it yourself?
Yes.
And where did that pat down take place?
Over at the patrol car.
At the patrol car. You didn't do it back at his car in the Impella. It was parked legally in the driveway on Wood. Why not?
Because he exited the vehicle, so he's moving to the patrol and he didn't want to get back in.
I understand. But, okay. But you chose to walk him away from the vehicle in cuffs? Yes?
He was handcuffed.
You told him, you chose to walk him away from the Impella vehicle while he was in handcuffs. Is that correct?
After he said there was no insurance.
Sorry, sir?
After he let us know there was no insurance on his car, that's what
No insurance is an arrestable offense.
correct.
Sure. But you already thought there was no insurance in the car because you said you checked lien.
Right.
So, was he more or less of a criminal when you got out of the car? More or less of a criminal after you made this check, or more or less a criminal when you said, I don't have insurance on the car?
He was just detained for not having proviso of the law.
Mr. Kilborn Little's response to you that he had no insurance was, I'm sorry, his statement to you that he had no insurance was the response to a statement you made that you checked lien, no insurance. And that's when you said, you're right, there's no insurance. Is that what I heard?
You kind of confused me. Can you say that again?
I don't mean to confuse you. Did he tell you that, or admit that there was no insurance after you told him you checked and found no insurance? Isn't that what really happened?
No.
Okay. But you'll admit that whatever the body worn camera dash cam will show is really the truth, yes?
It showed what it recorded.
So. Just let me nail down the thing that I think is most important to the court, at least to me. When Mr. Kilborn Little gave you permission to search the motor vehicle, the Impella, he was in cuffs, not free to leave the scene.
Right.
At what point did you advise him of his rights pursuant to Miranda versus Arizona?
He was read as Miranda inside of the patrol car.
Inside the patrol car.
Right.
So in terms of chronology and events, he had been stopped after exiting, told he wasn't free to leave, had some discussions with you at which time you asked certain questions while he was in handcuffs. And you didn't give him his Miranda rights until you put him in the patrol vehicle. Is that correct?
No.
I'm not correct?
No.
Well, all right, tell the judge where I'm not correct.
The order of what you said was
Go ahead, sir, please.
he was stopped and he exited the vehicle.
and immediately on his own indicated that he didn't have insurance prior to handcuff. He was subsequently handcuffed after he confirmed with the lien that the patient gave us.
Now, what about the rest of the discussion you had when we were asking the questions in full view of the dash cam with the body worn camera, and you had Mirandized them? Did that not happen? Did I miss that? Am I hallucinating?
I asked him general question, what's your name, whose house is this, things of that nature.
Judge, I have no further. Thank you, Trooper. I thought you said this was my bad, I'm sorry.
Trooper Edwards, you indicated that defendant told you at some point he knew the owner of the house at that address. Is that correct?
Correct.
At what point did the defendant make that statement to you? Is this after you've been placed in custody before?
Your Honor, that's beyond the scope of redirect examination. Question was not asked in cross. Please, Judge.
That's true.
Nothing further, Your Honor.
Have you also? Sorry, what's your- Yeah. Is it any water?
Yes, it is, yes.
Okay. Any other witnesses?
No further witnesses from the people, Your Honor.
Your Honor, the defense intends to call no witnesses. Thank you.
Okay, as soon as the trooper exits, then you can argue.
And Your Honor, the people would move to bind over on all counts, including the additional counts, 4 and 5, those being felon in possession of ammunition and the associated felony firearm charge. In this case, we had an instance where Trooper Edwards was on patrol. He ran the plate through lanes, determined that there was no insurance on that vehicle. They made contact with the driver. Again, this is while the vehicle was still moving down the street. It was an uninsured vehicle being driven. At that point, it backed into address. They made contact with the defendant who was driving that vehicle, obtained his consent to search that vehicle and discover that firearm in that vehicle, and loaded firearm in that vehicle. So again, the people would move to bind over on all counts.
Can you address the issue of consent to search? Whether or not the officer, or whether he argued in regards to whether or not you believe that Trooper had violated what the right to search the vehicle.
Yes, Your Honor. So in this circumstance, they detained the driver of that vehicle. And they detained the driver of that vehicle, and throughout the course of their investigation, they asked if they may search that vehicle. Alternatively, they did not know whose address that was that he had actually pulled into at that point. And given that this vehicle had no insurance, it would have been an inventory search of that vehicle prior to a tow. So again, Your Honor, the people would renew our motion to bind over on all counts.
Attorney Rosenberg.
Thank you, Your Honor. If this was a legitimate traffic stop made in a relatively short period of time between what might be considered to be a small number of houses from the corner of whatever to Whitfield, my client's fellow was seen back into the driveway. Whether or not he admits if the chronology is to be believed, there was no insurance on the vehicle. This is really no more than either a short-term, not to be extended traffic stop, or it's a violation of Terry from the get. You know, I can't imagine that the scores or hundreds of exams that this court has presided over, the hundreds that I've attended. where a police officer would not take the opportunity when it's offered to pat down somebody for offensive weapons to determine the existence or non-existence of those weapons for his safety of the people in the neighborhood. But that's not what happened. My client exited the vehicle voluntarily. Nothing can be read into that other than the fact that he left his impellant. Was told to get back in the car. He said, no, that's all. But as a result of the small measure of defiance, my client was cuffed. I don't care if the words arrest or not arrest were used. No indication that he was armed or dangerous. No pat down. Taken to a squad car. When his freedom was restrained in a significant manner. The only thing that's missing is the words, are the words, you're under arrest. It doesn't make any difference. He was subject to custodial interrogation, and he was subject to a question. May I search your vehicle with no reason, let alone probable cause, under the circumstances with the car legally parked at a residence with no other question therefore. Oh, let's just make an assumption greatly that sometime during that interrogation, at or inside the patrol vehicle, my client told the troopers that his significant other lived there as he did. Truth be told, I don't think it's far reaching. The court might surmise that the body worn camera where my client's significant other is actually there watching. The question is posed was non-Mirandized. The question is posed was done so under coercive circumstances, so that my client's consent, if in fact was given, cannot be said to be unequivocally given with any sense of I lost my train of thought, that the consent was unequivocal, because it wasn't. Case law follows that. And under those circumstances, a subsequent search that yields, in this case, a great deal of contraband would be, or could be, or should be considered the principal poisonous tree. So good faith exception allowed. Police officers put in a motion a set of circumstances that lead us here today. The court is charged with the responsibility of examining the entire matter. And under those circumstances, I have to ask the court to suppress the evidence that was gotten and dismiss the matter. Thank you very much.
Any rebuttal?
No rebuttal from people, Your Honor.
And I do believe that the stop, I mean, well, I would say stop. I believe that the search for of the whether or not the vehicle had insurance is lawful. And based off of the testimony from Trooper Edwards, he did observe the vehicle, the Chevy Impala that the defendant was driving on a public roadway, which is considered, it could be a misdemeanor or it could be a civil infraction, stated a misdemeanor in this case. So I do believe that there was a lawful attempt to stop the vehicle that the defendant was driving. My issue is with the consent search. The trooper said twice that the defendant was not free to leave and that he was in handcuffs when asked if the vehicle could be searched. And when analyzing voluntariness to search a vehicle, there are several factors. One factor is handcuffs. In this case, the defendant was in handcuffs, and the standard is also not what the officer believes, but what the reasonable person believes. Will the reasonable person believe that he or she is free to leave when in handcuffs? When it comes to being questioned, there were no Miranda rights given. He was arrested and asked if the vehicle could be searched. It's also not significant whether the defendant knew he could deny consent to search the vehicle or not. He did. So I am going to suppress and dismissed without prejudice on the simple fact that I do not believe that he was free to leave when asked if his vehicle could be searched. I believe the stop was legitimate and done correctly, or one way it could be done. But however, we're putting the defendant in handcuffs, and based on the reasonable person standard, I don't think he was free to leave and was in custody at the time when he was asked whether or not the vehicle could be searched. And the question is, was it inevitable that the weapon may have been found regardless of the registry? There was no testimony from the trooper that an inventory search was going to be done, or stated that the vehicle was going to be towed based off of the parked vehicle in the driveway. They had no insurance, so I'm going to dismiss without prejudice insufficient evidence. I always say this when I have to dismiss cases, I do not condone the behavior. This is a technicality. There were weapons found or weapon found in the vehicle, and still against the law, but based off of testimony, I do not have enough to find out in my opinion. So
Thank you, Your Honor. Will the court sign an order and will the court cancel bond?
Yes.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, we're gonna waive on Taylor.
Okay. Attorney, so yours is the case, right?
No,
No?
I don't hold
Oh, okay.
Your Honor, I have to see if officers are still here. I was told it's KPS officers, they left. It was, this was supposed to be.
He was here at 9:30, Your Honor. And I showed up at 9:45, unfortunately, because I was in front of.
Officers here, officers, did the defendant sign in at 9:30?
He walked up with me.
The defendant is here.
Do you know if he signed in at 9:30?
The defendant's gonna sign it, just check in with him. But yes, he's been there, he's been there.
I have to, Your Honor, my apologies. I do have to check the officers are still here because I was told that it was a KPS. So.
Everybody's still here.
Give me one, yes,
Everyone's
thank
still
you. Wonderful.
Okay. So let me handle the waiver and anything that's not a hold.
Your Honor, I also want to bring your attention, I don't know if you remember, but I was here on Ronald McLaren and we did, he wasn't here, I was trying to get in contact with him. He has an exam scheduled tomorrow in front of King. He's actually in custody right now. If you want to arraign him on the warrant and then you want to schedule the exam tomorrow or whatever is, people.
Do that when you come up for your.
Okay.
You did?
Sure.
What you got? Taylor. Case 2357479, people of state of Michigan versus
Sierra.
Sierra.
It's okay.
Taylor.
Yes.
Charged with count 1, assault with a dangerous weapon, assault, count 2, weapons on your firearm set for exam day. Appearances.
Morning, Your Honor, Danielle Parrish on behalf of the people, P85495.
Good morning, Your Honor. Leslie Knapp, 34696, appearing on behalf of the defendant Sierra Taylor. Your Honor, at this time, we're prepared to waive the exam. I have explained to Ms. Taylor her right to have that preliminary exam held, and that probable cause must be established. She wishes to waive that.
Is that correct?
Yes, ma'am.
Any objections from the people?
No objections, Your Honor. However, I would like to put it on the record. I am not sure, and please correct me, Your Honor, if I am wrong on what the current bond is on this defendant. I would like to put it on the record. People are adamantly requesting that there be no contact in this case Also, because these are charges that involve a weapon, we ask that the defendant, as part of the bond until this matter is handled, she is also a CPL holder. We are requesting that part of bond that there be no weapons, no contact with, when I say third parties, these are related individuals, Your Honor, so I can't go as far as no contact with third persons, but no contact that would be in relation to anything going on in this particular case.
Did something happen?
I didn't hear. Apparently,
I said, did
yes.
something happen?
I was told, and there used to be a PPO as well. And at this time, I mean, we can hold if you'd like to hold.
No, I just, the question is from the last time we were here on the 5th of July, has anything happened?
Your Honor, I do not know as far as if it was between now and the 5th, but since this incident, there, before, during, and after this incident, there has been issues. And I know that we're not going to be holding today, but the charges, the alleged charges are very serious. And because they are sisters, Your Honor, and there was a video that was, I'm sorry?
The complaining witness implicated?
Yes.
What happened? Because you're addressing it as if something happened. I can't tell the defendant what to do if I don't know what happened.
There's constant contact. I don't know if it is threats or just trying to resolve the situation, but now that it is in court, this situation needs to be resolved in court. I have told the defendant to not make any contact, but we can't, the complainant witness, but I need the defendant to not make any contact, even if it is of the trying to resolve the situation, there not to be any contact. And again, I don't know what the bail was originally, set, or what the stipulations or, that were necessary with that, but because again, this person, the defendant, is a CPL holder and is being charged with, again, alleged, I will say it, but nonetheless, a gun was involved in this.
Okay, the bond is 20,000 personal, no contact. I'm reading off of the register of actions. It says, no weapon, no contact with the victim, directly or indirectly. Is there something else other than just restating that on both sides? Sorry, now, do you have anything to say?
I do, Your Honor.
I want to wait so she can hear.
So again, Your Honor, it's and it may just be a matter of you having to restate that. I didn't know, and I appreciate you reading that off. I'm fine with that, but because they are related, they are sisters. This is summer, there's family events, things go on. The defendant needs to know that if the plain witness is there, she is not to go. That, I think that is where there's some, and then everybody starts getting involved in
Is that
this.
the issue, ma'am?
This is officer in charge.
Good morning, I'm not getting the answer. Could you explain what's going on as far as the bond here, and why there needs to be a readdressing of no contact?
Okay, you want me to state
Your
myself
name.
over? Okay. Good morning, Your Honor. Detective Lenita Brown, badge number D286. I'm now at the precinct. It's my understanding that my victim gives numerous family events, and the defendant, which is also her sister, just pops up. She did have a PPO that was put in place, and it has now expired. But because of the circumstances involved, and without going extremely into the case, her child was present, who's like an infant or a child.
Whose child?
The victim.
Okay.
Her child,
Ms. Goforth?
Yes, her child was present in the vehicle when all these allegations took place and the weapon involved. So she's fearful for her child, not only just her safety, but her child's safety as well. And both of them are CPL holders, is my understanding.
Thank you. Attorney Knapp, do you have anything you'd like to say?
Please, Your Honor, this alleged incident happened 2 years ago. The complaining witness got a PPO. My client did not oppose it.
She did not move to set it aside. She has not seen or spoken to her half-sister. It's a half-sister. They have a mother in common. She has not seen or spoken to her in those 2 years. I would note that my client also filed a police report the day this happened at a different precinct, so I haven't seen that police report because it wasn't provided to me. My client also immediately went to the gun board regarding her CPL to let them know that guns had been involved in this case. And I would note my client was in a car outside of her grandmother's house and the complaining witness came at her car. But that's a factual issue that I don't expect this court to resolve. My client has had zero contact with the complainant in any way, shape, and form, other than the complainant came to my client's house because she thinks their children should still be friends. My client didn't even answer the door. Yes, my client's getting messages from other family members regarding the complainant saying, I can hardly wait to put her in jail. But my client's not responding. She's had zero contact with this woman. I have no problem with the bond conditions as they currently stand, and I don't understand why this is an issue. No contact means no contact. My client wants no contact with her.
And that includes family events.
Exactly. I haven't been to any family event since this happened because she's drama and I don't like drama. I do not come around anymore at all.
Okay, I'm just telling you.
I stay home.
Yeah.
Is the complainant witness here?
Pardon me?
Is there a complainant witness here? Can you have her come to the back of the courtroom so I can, before I buy this over, no contact for both parties?
Both sides. Thank you.
Can you bring in Ms. Goforth just in the back of the courtroom?
What, Judge?
Jasmine Goforth. Is the complainant witness?
Your Honor, the officer in charge did obtain some additional information as you did ask us if there had been any contact since that incident.
Okay, you know, I don't want to try this case. Ma'am, can you put your name on the record?
Jasmine Goforth.
Okay, Ms. Goforth, we are discussing the no contact order that was put in place by the previous magistrate who arraigned Ms. Taylor on this case. There have been some facts brought up that there may have been some contact. I'm not going to get into all of this. This is being bound over Third Circuit. You are not to contact Ms. Taylor. Ms. Taylor is not to contact you. You are not to contact her through third party. Same Ms. Taylor, same, you're not to contact your half sister, Ms. Goforth. And at this time, family function right now, stay away from each other based off of what I've heard, and no social media. I mean, Instagram, Twitter, Facebook, all of it, nothing. Through third parties, no text messages, anything. Understood?
Yes, ma'am.
Okay, got a yes from both parties on the record. So, Ms. Taylor, as I was saying, did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you anything?
No.
Okay. I find your waiver to be freely, understandably, and voluntarily given, so you'll be bound over to Third Circuit Court. Your arraignment on the information date is 2 weeks from today, July 25th at 9 o'clock, and bond is continued. Okay?
Thank you. Have a good day.
Thank you, Your Honor. Good to see you. See you next time. What date did you say? The 25th?
25th, yeah. 2 weeks, exactly 2 weeks.
Okay, sometimes they're 3 and other times they're 2.
I only do 1 and 2. In custody for 1, not in custody 2.
Plymouth is doing 3 weeks now, and I'm not quite sure
Maybe
why.
we're a little more.
Yeah, everything's more important.
Right.
Have a good one, everybody.
You too.
I'll see you next time.
Thank
Danielle, it was super nice talking to you.
Nice to
Have a
meet you
good
as
day.
well. Have a great day.
I didn't see that. You did that. That was not. Yes. Yes, I did.
How you doing?
He's my person.
Somebody down here?
Or 11 o'clock.
Yes.
Thank you.
I thought he was here.
As far as I know, he's not.
Yeah, today is just different than.
He is not, Judge. According to him, Judge, to the OIC on that case, he picked up a new case last night or this morning.
Come on up. I'm sorry. 2357560, the people of the state of Michigan versus Martin Lukas, charged with one count of stolen property, receiving and concealing a motor vehicle. The second offense of the set on exam today.
Good morning, Your Honor. For the record, Jeffrey Glazer, P46892, I'm going to move down.
And we do not have your client present, correct?
Judge, he was locked up in the Wayne County Jail. He must have bonded out or got tethered out. Having said that, it's my understanding he picked up the new case last night. He's back in the jail.
Which jail? Wayne County Jail? We don't know.
Let me check real quick. Where?
MDOC.
That's where they dropped him off. Okay.
So
regardless, he's not here.
Correct, Judge.
Okay.
I guess I'm asking for an adjournment for the exam to begin with here.
Okay, I'll charge it to the court as you have control over this transporting, whether or not he appears today. Let's see. You all are the witnesses on this case? I'm the right.
This is a defense case, I believe he's outside of the speaking to what is. Yeah.
So I did the, oh, I see.
Yeah, I'm the
You also
officer
on the
that
case
arrested.
as well?
Yeah.
Okay, I just wanted you all in here so that you look at date.
DDC.
DDC.
Yeah, DDC.
You said DVC?
Yes.
Okay. Well, it's closed. So we'll need a week. Is the 21st at 9 o'clock work? That's a Friday?
It does, Judge.
Yes. That works? Yes. Okay. Okay.
Thank you so much. Have a great day, Judge.
You too. No attorney Hamilton, oh, yeah,
No attorney, Judge, I left emails.
Okay, 2357557, people of the state of Michigan versus Maisha Tamiko Rankin, charged with one count of motor vehicle unlawful driving away, statutory exam today appearances.
Yes, Arnold Fink, P 13426.
And people,
This is David Kelly on behalf of the people, P number 86690.
and Ms. Rankin. Please state your full name, please. Maisha Tamiko Rankin. Okay, good morning, Sue. Is it correct you were just retained on this case?
Yes, ma'am.
Okay, do you have discovery yet?
I don't have anything.
Okay, I'm sure the people provided, now that we know you have
That's
been
correct, Your Honor.
retained. How much time do you?
I tell you what, I would appreciate it maybe in August, sometime it will be August, please.
August first?
What day, what
It's a
day?
Tuesday.
That'll, August first will be fine.
Okay. Can you do 9 o'clock? Be the first case, so you won't be here for lunchtime?
Yes, ma'am.
Okay. It's right, your exam has been adjourned to August first, 9 o'clock, in person.
Tuesday. 1:34.
Attorney Hamilton, can you hear the courtroom?
I was looking.
Yeah. Good morning, Attorney Hamilton, can you hear, well, afternoon, can you hear the courtroom, ma'am? Can you hear the
Yes, I
courtroom?
can. Yes.
Okay, Judge Sabree had me contact you for it was Yaya Keita.
Yes, I had it for a different day and I apologize. Did he appear at all?
Let me check console. I do not have him checked in, Attorney Hamilton. But we do have witnesses. Let me check with the officer. We had quite a busy day. So let me be sure, but I know we do have witnesses and I do believe your client is in the hallway. Don't quote me. Hold on just a second, okay?
Okay.
I'm pretty sure he is. Attorney Hamilton, I apologize. The client is a jailer. That's what was my confusion. I got it confused with someone else. It's a jailer. So we do have witnesses and everything here. So the judge stepped away for just a moment. I'm uncertain on how to proceed, so I'll just wait for Judge Sabree to come back. Are you near the courthouse or are you in any other proceedings somewhere?
You know, I'm nearby, so I can just head over there, or if you guys are about to, I don't know if you guys break for lunch. But I can head over there now or be back at a set time.
Okay. I can let the judge know if you want to hang out for a minute or two. And let me see if she's in the hallway, the judge. But are you gonna head over? Do you have an ETA, Attorney Hamilton?
I can be over there in 15 minutes, possibly less.
Okay, I'll pass the message along and thanks for logging in.
All right, thank you.
Okay, thank you.
Okay, on the record, this is people in Michigan versus the county Clifton, 2357213. Mr. Clifton is charged with one count of weapons carrying concealed, set for exam today. Appearances.
Good afternoon, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Alyssa Severo with the Neighborhood Defender Service on behalf of Mr. Clifton, P86432. Mr. Clifton, could you please state your full name for the record?
County Regular Clifton. Good afternoon. Any preliminary matters before we begin?
None from the people, Your Honor.
Your Honor, we would just ask to sequester all witnesses.
There's anyone on YouTube or Zoom who may testify or is a witness, now's your time to log off, as well as the courtroom. If there's anyone who may testify or is a witness, now's your time to exit the courtroom. With that, you call your first witness.
Thank you, Your Honor. People call Officer Sydney Holmes.
Sabree, tell us your Yes, ma'am. Door opens right in the front, just make sure you speak up in the microphone when you respond. Whenever ready, Ms. Parrish.
Yes, Your Honor, thank you. Officer, I'm gonna ask you a set of questions. If I'm a little hard of hearing, feel free to move the mic. You can also place it on your lap if more convenient. If there's a question I ask that you don't understand, please stop me and I'll rephrase, okay? Yes, ma'am. Could you please restate your name for the record? Officer Sydney Holmes. Officer Holmes, can you please tell us where you're currently employed in and what capacity? I'm a police officer with the Detroit Police Department. How long have you been a police officer? 3.5 years. Were you employed in this capacity on June 2nd, 2023? Yes, ma'am. Were you by yourself or with partners that day? I was with 2 partners. Can you please tell us your partners' names? Officer Prudhomme and Officer Haggard. Were you in full or modified uniform on that day, officer? I wear a modified uniform. Could you please explain to the court what that entails? I wear a black polo shirt like I'm wearing now and green pants, which I'm wearing now. As you say, when you say wearing now, I see your shirt has your name as well as a badge on the front. Does it indicate police anywhere on the front or back? Yes, ma'am, my badge says police on it. I also wear a vest that says Detroit Police on it. Were you in a scout vehicle or on foot that day? I was in a scout car. Was your scout car marked, fully marked? It's semi-marked. Okay, and could you please tell us what that entails? It is a black SUV that says Detroit Police and gray writing on it. Okay.
Ms. Parrish.
Yes, Your Honor.
I want to interrupt. Did you want your client at the table?
Oh, yeah, you can come to the table.
And I'm sorry, you were describing the vehicle. Where does it say police on it? It says it on both sides of the vehicle. Is there any lights? Yes, ma'am. If your duties as a Detroit police officer take you at or near 11762 Connor Street in the city of Detroit, County of Wayne? Yes, ma'am. Could you tell us what you were doing at or near that location? I was in routine patrol coming off of Sanford, going north on Connor. And while at or near said location, did you observe something, officer, that drew your attention? Yes, ma'am. I observed an individual walking on the sidewalk, a white t-shirt on their right hip. I saw what I believe to be a concealed pistol. Why did you believe it to be a concealed pistol that you were observing? I could see the handle of the pistol pushing against the shirt. I could also see a small square, which I know to be the butt of a handgun. Based on this observation, what did you do? At this point, my partner had passed the individual. We did a U-turn. I saw the individual again. out of the vehicle and approached this individual on foot.
You stepped out of the vehicle?
Yes, ma'am.
What did your partner step out of the vehicle as well?
I believe so, ma'am.
Okay. After you stepped out of the vehicle, did you make contact with this individual?
Yes, ma'am.
I'm sorry.
Sorry. As I got closer, I could continue to see the object that I saw previously, which I confirmed to be a firearm. I asked this individual if they had a concealed pistols license, which they stated they did.
And just let me stop you there just for one moment.
Yes, ma'am.
Could you identify this individual if you saw them again?
Yes, ma'am.
Is that individual in the courtroom today?
Yes, ma'am.
Could you please tell us where that individual is and what clothing they're wearing?
He is sitting to your right. He has a green shirt on and khaki pants.
Your Honor, may the record reflect, please, the identification of the defendant.
So reflected.
Thank you. Officer, so you indicated that you approached and made contact with the defendant. The last thing you said is that you asked, you inquired about CPL?
Yes, ma'am.
Okay. And what was his response to your question for the CPL?
He stated he did have a CPL.
Did he do anything while he indicated that?
He attempted to produce one, but failed to do so.
Okay. Could you please tell us how he attempted to produce one?
He took out his wallet and started to look through the cards.
Okay. And as you just indicated, at any time did he produce a CPL?
No, ma'am.
Did he give any reasoning as to why he could not produce a CPL?
I believe he stated that it was at home.
Based on the defendant's failure to produce CPL, what if anything did you do?
I took their Michigan identification card and I ran the information in lead to see if it had a CPL.
Objection, Your Honor, hearsay.
What part?
The lien.
Lien is not hearsay, Your Honor.
You said you ran lean?
Yes, ma'am.
Okay, I'm gonna overrule that objection.
Officer, once you obtained, just want to step back a little bit so that I can paint a picture for the court. You indicated that you obtained the defendant's Michigan ID.
Yes, ma'am. It was an ID card or a driver's license.
And did you observe anything that your partner did as you obtained his identification?
As I was getting his identification card, I observed my officer, or my partner officer, Prudhomme, recover one bloody handgun from his right hip.
Can you tell us why your partners recovered the weapon?
It was for officer safety, and at this point, he wasn't producing a CPL.
Did you observe the type of weapon that your partner recovered from the defendant?
Yes, ma'am.
What type of weapon was it?
It's a black Taurus.
And did you observe whether the weapon was loaded or not?
Yes, ma'am.
Was it?
Yes, ma'am.
In the course of your investigation, you indicated that you obtained his identification and ran lean. Were you able to verify whether or not the defendant indeed had a valid CPL as he had indicated?
Yes, ma'am. His CPL had expired over a year.
Over a year prior to that incident date?
Yes, ma'am.
In the course of your investigation, did you have an opportunity to find out whether or who this weapon may have been registered to?
I don't recall, ma'am.
After verifying the defendant's invalid CPL status, what if anything did you do at that time?
At this point, I notified my partners that he was going to be under arrest.
Was at that time, was the defendant detained?
Yes, ma'am.
Was he arrested?
Yes, ma'am.
What was he arrested for?
Carrying a concealed weapon.
Was the firearm recovered, that was recovered from the defendant, was that placed in evidence?
Yes, ma'am, it was.
Further questions at this time? Thank you, Ms. Brooks.
Good morning. Good morning. When you stated on direct that you had approached or had driven past Mr. Clifton and then did a U-turn, reapproach?
Yes, ma'am.
So when you first drove past him, were you closest to him or going the opposite direction?
We were closest to him, same direction.
Same direction. So when you did a U-turn, you were back in close, you were the one in passenger seat, correct?
I was the passenger, yes, ma'am.
Okay, so you were the closest to Mr. Clifton.
I was the closest to him when I first saw him.
And how far from him were you when you first seen him?
The distance between a sidewalk and that little strip of grass and then the street, so 20 feet is that.
And you said you've seen the butt of a gun?
Yes, ma'am.
Was his shirt, was it up on top of it or over it?
It was over it.
And then you stated you approached him and asked him how to CPL.
Yes, ma'am.
He indicated that he did.
Yes, ma'am.
Is that home?
Yes, ma'am, yes.
No further questions, Your Honor.
Court announces, but just for the record, could you please indicate why you asked for, as far as the CPL, is a person who carries or has a CPL, is there any requirements while carrying a concealed weapon for that CPL?
They shall identify themselves when asked by a police officer, and they shall show us their CPL card.
If they fail to do so, is that a violation?
Yes, ma'am.
No.
No, Your Honor.
You're on. Any other witnesses from people?
No, Your Honor.
Any defense witnesses?
No, Your Honor.
So this officer steps out, we can begin arguing this marriage.
I apologize, Your Honor.
As soon as the officer steps out, you can begin arguing.
People move, the defendant, the convict Clifton, found over a compound weapon carrying concealed and reserve argument.
Yes, Your Honor. We would object to the bind over in this matter. While Mr. Clifton was unable to produce a CPL, we did have a CPL at one point. And unfortunately, the CPL did expire. For reasons, unfortunately, we are not able to discuss here today, as I did not get out of the witness that was called. However, I do want to report that this is a sympathetic case, and we would just ask for that matter that this case not be found over.
Your Honor, the situation is indeed sympathetic, we understand. Unfortunately, it is a question of fact or prior fact, probable cause has been met here and shown that. Unfortunately, the defendant did not have a valid CPL. So, you know, we hate to see these circumstances. Hopefully something can be worked out, but at this stage, probable cause has been met. Therefore, we ask that it be bound over. Thank you.
I would agree with both parties as far as the circumstances here and how unfortunate it is. We have to follow the law. I can't dismiss the case based off of sympathy. I do believe people that have met the burden of proof, as Officer Holmes testified, she was driving past the defendant and was observed and described to be a handle pushing against the shirt from the defendant and saw a small square. She did a U-turn, or the partner did a U-turn, stepped out the vehicle. And as she got closer, she confirmed the object was a gun that the defendant was holding. She asked the defendant if he had a CPL. He said that he did. He attempted to produce one, he failed to do so. As he was looking for his wallet, he said that he was at home. Officer Holmes then took his identification card and ran through Lean and discovered that he did not have a CPL because it was expired. And at that point, he was under arrest for carrying a concealed weapon. These are cases that I consider ones that trouble me as far as safety of the community. I don't believe the defendant has a criminal history. The gun was registered. Actually, I don't know.
so I'll take that back. But he did have a CPL, we have a right to carry a gun with a CPL, which is expired. Nevertheless, sir, I have to find you over, okay? So you'll be bound over to Third Circuit Court. You are out of custody, so your arraignment on the information date will be 2 weeks from today, so it'll be July 25th at 9:00 a.m. And depending on the judge, it may be in person or on Zoom, but your attorney will give the information. And bond is continued, and anything else before we're off the record? Okay. Okay, you all set? Thank you for your patience today. Yes,
He is in custody.
this is off the record.
Yes, sorry. Yes, he is in custody. And I know that we had said that we would bring him in on the 12th. Do you just want to do that tomorrow? I will just be here tomorrow. Well, that would have a call.
In person, Judge King.
I will be in person with Judge King. I think that they will bring him because they know that he has an exam. So then after the exam or whichever is best, we can then bring him into this courtroom.
Okay, so make sure to let court officers know that he's brought up 438. Okay. For his arraignment and he's.
Okay, sounds good. Thank you.
Your Honor, is this a case that I need to know or say something for tomorrow, or is this a case that's actually in Judge King's?
The defendant has, was habeas to hear on another case.
Yes.
And I said that if, for instance, you were to find her client, I would arraign him against a PCC day. He is in custody, so he has an advantage king tomorrow, so we're gonna have to brought up to just give him a date for PCC.
Can you put some type of, something like this on the docket for tomorrow? Whether that's a PCC, just so our system has it, Your Honor, so that once we get them going again. Thank you, Your Honor.
I think it's Alex that's gonna be on that. I remember. Oh, no.
Not yet, not today, what's gonna happen? Yeah. We have an exam at 1:30, it's gonna take 5 minutes.
Okay.
Staff got to take a break here.
Let me see if I can.
Yeah, I think I just need digital on it, so.
Shoot me an email and CC Alex on it.
2357158. People of state of Michigan versus Yaya or Marquita, charged with one count of stolen property, receiving and concealing a motor vehicle, accident number 1. Set for exam, state appearances.
Good afternoon, Your Honor. This is Dan Duquette on behalf of people, number 86690.
Good afternoon, Your Honor. Vanessa Hamilton, 82107, on behalf of Mr. Kita, who joins us to my right. Sarah.
Can you state your full name?
Omar Kita.
Good afternoon. Long day. Okay, today's day set for exam, is it correct? Mr. Kita will be waiving his exam today?
That's correct.
Any objection from the people?
No objection, Your Honor.
Okay. Okay, Mr. Keita, I'm going to ask you a series of questions. If you can't hear me or if you don't understand me, let me know, okay? And make sure you speak up for the court reporter. Awesome. Is it your wish to waive your preliminary exam today?
Yes, ma'am.
You understand that you have a statutory right to an exam?
Yes, ma'am.
And that if you were to demand that exam today, the people would have to show that the probable cause standard, which is a much lower standard in criminal law, but still a standard, that one charge I read off was committed in the city of Detroit and that you probably committed that crime. You understand that? And that by waiving your exam today, that means the people do not have to present any evidence at the probable cause standard. Understood? Knowing that information, do you still wish to waive your exam? Did anyone force you or threaten you to waive your exam? Did anyone promise you anything? Okay, I find your waiver to be freely, understandingly, and voluntarily given, and that's with no objection from the people, correct?
No objection, Your Honor.
Okay. Anything before I bind over Mr. Keita?
No, Your
Okay. All right, Mr. Keita, we bound over to Third Circuit Court. You are in custody, so it'll be 1 week from today. Your arraignment on the information day will be July 18th at 9:00 a.m. And I don't know if it'll be in person or on Zoom, depending on which judge you get, okay? And bond is continued. You are on a hold on a different case,
Oh, I don't have a hold on this case no more.
so why are you still?
This was gonna ask the court, if the court has reflected that the GPS tether is from this case.
I have a 5,000 person.
Okay, so then it's from your other case. I take it.
Making sure. It does say tether requirement imposed. But it's still a personal line.
Okay, so it's requiring me on the tether.
But you can be released, but you just have to be released on tether.
You'll probably take
So you should not be in custody based off this case.
I think you're.
You're welcome.
Thank you, Your Honor.
Oh, thank you. Officer McKinney, I need you all to sign the waiver.
Oh, thank you.
And then it'll be all set. Contributed somehow. Okay, we're on the record. This is the people of the state of Michigan versus Aisha Renee Ingram. Case 2355116. Ms. Ingram is charged with count 1 as defendant 1 with forgery of document affecting real property. Count 2, uttering and publishing a document affecting real property. Count 3, real property reporting fraudulent conveyance. With the habitual offender second offense notice set for exam today. Appearances.
Good afternoon, Your Honor. Latoya Willis, P64900, appearing on behalf of the people.
Good afternoon, Your Honor. Max Manukian, P76341, appearing on behalf of Aisha Ingram, who is present at the same time.
Now, can you state your name, please, for the record?
Aisha Renee Ingram.
Thank you. Okay. Any preliminary matters before we start?
No, Judge, I would ask you to make a motion for a sequestration asking an exception for the officer in charge.
Okay, any objection? Okay, if there's anyone on YouTube or Zoom who may testify or was a witness on this case, now is your time to exit Zoom or YouTube with the exception of the officer in charge. If there are any witnesses or anyone who may testify, now is your time to exit the court. Anything else?
No, Your Honor.
Mike
Springs.
Walk toward the court reporter over there. You know, state your name.
Okay. The door opens right in the front and I said yes. Once you respond, make sure you speak in the mic. Okay.
Good afternoon. Please state your full name for the record.
Spring Smith.
And Ms. Smith, how are you employed?
I am employed with the Wayne County Register of Deeds as the Director of Operations.
As the Director of Operations, do you have access to the official records of the Wayne County Register of Deeds?
Yes.
And would those be documents? Would those records include quitclaim deeds or title documents recorded with the Wayne County Register of Deeds?
Yes.
I'd like to approach with what's been marked as People's Proposed Exhibit Number 1. Commissioner,
yes.
I'm handing you a document that's been marked as People's Proposed Exhibit Number 1. Will you indicate for the record what that document is?
It's a judiciary deed in lieu.
And is that a 2-page document?
Yes.
Is that a document that would have been recorded and kept as a part of the official Wayne County Register of Deeds records?
Yes.
How do you know that?
There is a stamp on the top of the document that says Bernard J. Youngblood, Wayne County Register of Deeds. The document is also time stamped along with a library and page and document numbers.
When a document is recorded with the Wayne County Register of Deeds, does each document receive a particular or specific library number and page number?
Yes.
And does that document or will that number differ for each item that's recorded?
Yes.
People's Proposed Exhibit 1, does it indicate on what date that document was recorded?
This document was recorded on December 6th, 2019 at 10:55 a.m.
People would move to admit People's Proposed Exhibit Number 1 into evidence.
I would just state an objection for the record to whether Ms. Smith in her capacity can authenticate this deed not being the person that recorded it.
Thank you, Lord, the document would be admitted as an official record, business record. Let me go back and ask the question that I don't think I did ask. The document that you have in front of you, People's Proposed Exhibit 1, is that a document that would be regularly kept in the course of business with the Wayne County Register of Deeds?
Yes.
So my response would be that the document being kept as a regularly conducted course of business with the Wayne County Register of Deeds would count as a business record, an official business record that would be admissible as such.
You tell me, Judge?
I'll withdraw the objection.
All right, it'll be a minute as people do this once. Thank you. Permission to approach with People's Proposed Exhibit number 2. Actually, 2 and 3. Ms. Smith, would you take a look at proposed exhibit number 2? And if you would just indicate for the record what that is.
The document is a quick claim deed.
And the document, is that a document that was filed with the Wayne County Register of Deeds?
Yes.
How do you know that?
The document is stamped with Bernard J. Youngblood, Wayne County Register of Deeds. It also has a instrument number along with the library page, recorded on March 10th, 2020 at 10:33 a.m.
The proclaim deed that you have as People's Proposed Exhibit number 2, does it indicate who the grantor of that document is?
It's quit claim to Aliyah Ingram.
Who's the grantor on the document?
Lorraine Morris.
And the grantee?
Aisha Ingram.
And the date on that deed?
The date of this deed is March the 10th, 2020, 10:38 a.m.
Is there a date that the document was executed?
The date. Okay, the date is December 24th, 2019.
You indicated that the document was recorded with the Wayne County Register of Deeds. Is that a document that is kept in the regular course of business for the Wayne County Register of Deeds?
Yes.
People would move to admit People's Proposed Exhibit 2 into evidence.
No objection, Your Honor.
Okay, it'll be admitted as Exhibit 2.
At the time that a document is recorded, are there any documentation that is presented to the individual that's recording the document?
There would be the document and an ID.
All right, and are you able to determine whether or not the individual that presented Exhibit 2 for recording presented any identification?
Yes.
How do you know that?
We can go into our database, which is the Tyler Eagle system, and look at the document index, and it indicates who actually brought the document in and whether or not they presented ID.
And in this instance, the individual that recorded People's Exhibit number 2, does it indicate who that individual would have been?
Yes.
Who would that have been?
Aisha Ingram.
Objection, Your Honor. This is relating to some sort of record that she has in her possession. I've not seen it.
Correct. Well, I'm sorry, it's Exhibit number 3.
Proposed Exhibit.
Proposed Exhibit number 3.
You wanted to see what that is before?
She did show me proposed exhibit number 3. I have it here. Let me just have just 3 moments. I see, Your Honor, it does not appear that people's proposed exhibit 3 was provided to me in discovery. It's double sided. This is also sided. These are your only exhibits. The first two were. Yes, it would.
Just could we, make a copy of this exhibit?
How many, just one? You need a moment to review?
I would like a moment. I guess if I could just ask this question, is this exhibit being proffered for the purpose of proving that Miss Ingram was the one that reported the deed?
Yes.
Judge, I would ask that that comment be stricken from the record.
If it was. where it
We'll say it for the rest of this hearing. We'll see that first. Okay.
Okay, so you're asking if this document was being admitted or proper so that you can prove.
After seeing the document, I'm not sure how that. I would object to its admission on the basis of probative value, as this doesn't show any sort of information on it that identifies Miss Ingram. It just says her name on it. There's no identifying. There's nothing. It literally just. It doesn't even say her name on it. Oh, it does. It says her name and there's nothing else.
Okay, I guess if it was, you can better explain what is being offered for.
It's a receipt. If the witness is allowed to continue testifying, she will indicate what the receipt is, how it is related to the case.
Okay.
And then you can object.
Sure.
People's Exhibit 3, we indicate for the record what that is a copy. People's Proposed Exhibit 3, we indicate for the record what that's a copy of. Oh, I'm sorry.
It's a copy of a receipt.
What type of receipt?
A receipt that was given at the time that the document was recorded, once it was paid for.
And how do you know that that's the receipt that's affiliated with the quick claim deed that was recorded? Are we speaking about admitted exhibit number 2?
Yes.
How do you know that that receipt goes along with exhibit number 2?
The product type is a quick claim deed. The document number is 20200572292, which is the same document number
on the label for the quitclaim deed that has been presented in Exhibit 2.
And for each document that's recorded with the Register of Deeds, is there a receipt that's generated?
Yes,
And are those receipts documents that are kept as a regular course of business with the Wayne County Register of Deeds?
yes.
People would move to admit people's proposed Exhibit 3 into evidence.
Judge, I would maintain my objection on probative value grounds. Aisha Ingram is a common name. There is no identification beyond the name on that receipt. And Ms. Smith is not the person that recorded the deed and is not able to identify Ms. Ingram.
The identification.
The document, I believe the document should be admitted it's not based on whether or not defense believes that it's of any evidentiary value. It's a record that is being maintained as a business record with the Wayne County Register of Deeds, and it was generated as a result of the document that was recorded. So it is evidence, direct evidence of who recorded People's Exhibit number 2.
I'm going to admit, as Ms. Smith has testified, kept in the regularly conducted activity, course of business with the Wayne County Register of Deeds. As far as ID, there's been no testimony that she's identifying anyone in the courtroom that that's the person.
At the time that that document was recorded and the receipt was generated, does it indicate whether the individual produced any sort of an identification?
Yes.
And how does the receipt reflect that?
Next to Aisha R. Ingram, there is ID. That indicates to us that the ID was presented at the time of recording.
At the time that the document is recorded, is there any other information that's generally requested?
Yes, a phone number.
And in this instance, in preparation for this exam, were you able to go back and see what phone number was used when recording this document?
Yes.
Do you have that information?
Yes.
Could you indicate for the record the phone number that was used when the document was recorded?
Area code 313.
I'm sorry, Judge, I object. This would be another document that I don't have.
I believe this is the same, this is Exhibit 3.
Yes. It's.
I don't see a phone number other than the 224 number.
The phone number that is given, where is that information maintained?
It's maintained in the index of the Tyler system.
Does it appear on any of the documents that are printed out, such as the receipt?
No.
Is it a phone number that is stored in a database?
Yes.
And so that phone number is not generated on any of the receipts that are supplied or given out?
Correct.
Okay. So when you prepared for today's exam, is there something that you did to locate the phone number?
Yes,
What did you do?
I would have looked into our Tyler Evo system and looked for reception information to see who the person was that name associated with the transaction, along with the phone number that was given during the time of recording.
Judge, I object to the use of that, that is a document and I don't have it.
Well, I don't think it's been established or asked that is a document yet. I don't think that's even been established or asked.
Well, she's not reciting the number by memory, so this is.
I think if it was trying to establish place of
Okay,
foundation.
I'll wait.
Yeah, let's see how, I need to see where this.
When you review the database, the Tyler database, you said that there was a phone number that was affiliated with the file.
Yes.
That phone number you've indicated does not appear on any of the paperwork that is generated regarding the property for public use. Would the public have access to that phone number?
No.
All right. So the only individuals that have access to that phone number are?
That would be the employees at the Wayne County Register of Deeds.
All right. And so when you saw that phone number, when did you pull up that phone number?
This afternoon.
All right. And what did you do when you pulled up the phone number affiliated with the file?
Wrote the phone number down.
And what did you write the phone number down on?
On a sticky note.
Okay. That document, is that the only place that you have written down that phone number?
Yes.
Judge, I object. This is discovery and it was not provided to me. And this is now the second in our first witness, and in the first 10 minutes of our first witness's testimony, the second document that is referred to and has been a discoverable item that was not provided to me. So if the people, I would not object at this point to an adjournment of the preliminary exam date, but I no longer feel comfortable going forward with this exam with multiple documents just being brought up on the floor.
Judge, in response, the witnesses could have clearly indicated there is no document associated with it. This is a database that she is going to look through in preparation for exam to verify the information regarding the individual that recorded the document. There is no report or paperwork that was generated. There is simply a phone number that is in their system that is not made available to the public and would not have therefore been provided in any sort of generated report. I believe, however, that this is no surprise because the investigator's report itself indicates that the defendants recorded the document.
Okay, so two things here. One, you're objecting to the form of the posted that's trying to be admitted as business document?
Yes. I object to that. I object to.
Well, is it being asked to be admitted? The posted that she wrote the number on?
Not the posted, no. She would just be indicating the phone number that was held in the database.
Judge, if I can clarify my objection.
Please.
This testimony is being allowed in against hearsay as testimony related to an official business record. The semantics of whether a database counts as a document aside, this information was recorded in a system. That recording, I have never in my career encountered a situation where there was something that was recorded and testified to as an official business record that was not provided to me in discovery. I can't fathom how that would be non-discoverable. It's in a computer. There are screenshots. I get screenshots of text messages. I get screenshots of, I mean, pretty much everything here other than the deeds itself were screenshots. Printouts of, just because it doesn't say you can't, print out a clean copy of it doesn't mean that it isn't a document. It doesn't mean that it's not discoverable. and it doesn't mean that it's, strike those last two sentences. Judge, this is an official business record. I absolutely, whether there is, you know, evidence proffered elsewhere in the police report regarding, the recording of the document, if she's gonna testify to an official business record, I need that record.
Judge, she's testifying more so to a process at this point because the recording receipt indicates that there's identification that's presented. That identification is not stored. So that identification is not presented as a business record. There's information that is provided to the clerk at the time that a document is recorded, that is entered into their system that does not necessarily generate a business record, but it is information that is received by the clerk and stored in their system. I believe that this phone number will count.
This is the same type of argument when it comes to lien and officers providing information from the database.
Yeah, but there's a specifically enumerated, exception. I don't think it is. That the lien information, there's tons and tons of law that mandates that information not be, proliferated in any way. I don't think that that's the case with this Tyler system.
Was there ability to print out the document?
Is there a document at all associated with the phone number?
No.
May I ask a question? Does the phone number appear on a screen? Is that how you recorded it?
Yes.
And could you have done a print screen of that screen on your computer?
Yes.
That's a document, Your Honor.
Okay, second question, issue, Brian, on that. Is there any other documentation that needs to be reviewed with defense counsel that you may be entering that he does not have or may not?
No,
see
Judge.
For some reason?
These are the three exhibits that people are introducing. I provided the three exhibits.
The third exhibit 3 was provided to me as it was, as you just before we held the exam. And I understand, I know that this is really, sort of intricate and convoluted, and I know that the point is trying to make it very simple. However, I have to advocate zealously on behalf of my client's best interest. And, I do wonder, I don't believe that you were aware that this was a document that she was referring to prior to her testimony. I wonder, going forward, how much of this testimony and how many of these witnesses are going to, because I came into this exam in, very skeptical of the amount of discovery that was provided to me. And I was believing that all of the discovery was provided to me. And on a strategic level, I believe that, if that's all they got, then it's gonna be good for my case. I don't wanna bug and ask them to get more. But now that there's new stuff coming out, I clearly have incomplete discovery.
First response would be that, yes, I did know that she would be testifying to the exhibits that she has today. My second response is, you
don't want to take a moment to just go over the discovery of the record?
Yes.
Roughly.
Judge, I had raised the issue.
Oh, wait, hold on, okay, we're back on the record. Go right ahead.
Judge, I had raised the issue off the record that in my discussion with my client, it became apparent that in the landlord-tenant action that was involving this alleged transaction or property, there was a hearing that in which you presided over that case with Ms. Ingram as the defendant. I'll allow you to explain.
Okay, and I have never been on the landlord tenant docket. I believe this happened before 2023.
Yes.
So it would not have been my brother who people confuse us with. When it comes to cases, I have no recollection of any landlord tenant cases that I've ever done. It would have been when I was covering for someone else. The proper course of action, if you believe there's an issue, would be to file a motion to disqualify. But just letting you know, I have no recollection of ever presiding over anything regarding, I don't even know the property address in this case, nor do I know Ms. Ingram or for her or any parties in that case.
And Judge, I respect the court and I fully believe that, and I do not think it's an issue, so I would not be bringing that.
Okay. All right.
As to the adjournment, the request for the adjournment, during the break, I did take a look at my file to compare the evidence that's in my file with the discovery package that was provided to council. It does appear that there are several documents related to a quiet title and one document relating to title work or title, a sheriff's deed that was not provided in the discovery generated to council. Okay, and
For that reason, Your Honor, I would move to adjourn the preliminary exam at this time to allow us to review all discovery.
Very well. And
I would furthermore, I would ask if sister counsel could prepare a discovery packet with what she has.
can you
do
actually?
that and not through PPK?
Yes.
Okay.
So do you want me just to provide the documents you don't have? Because everything else.
I'd like to have them electronically. If that's asking too much, it would be fine. Just take it.
No, I'll send you these electronically.
Okay, yeah, that's perfect.
Okay, and just to be clear, I was hearing testimony from Ms. Smith and Nicholas, we were in the middle of questioning her about
People's proposed exhibit number 3?
Three
Was
was
it admitted as a 3?
3 was admitted, however, the issue was the phone number where the objection began, where we broke up. So Ms. Smith, we'll have to come back to the testimony level. We have a date of August 3rd at 11 a.m. for everyone in the courtroom who also has to come back and testify. That's the new date. At that time, we should be able to move forward with no discovery issues, any conflicts, and no tigers getting for anything else. Thank you. Anything else for the record?
No, Judge.
Okay.
Thank you very much, Your Honor.
Thank you, Your Honor.
Sorry for being annoying.